morning. Let's try that one more time. Good morning. Welcome on behalf of Judge Hood and Judge Young. Welcome to our first of 2 days here in Lansing for what we call case call. Let me first note that we are starting a little bit early, and that's because we have a lot of cases on the docket today. We also have a lot of folks who are endorsed, and we've got pretty dense cases as well. So as a result, we wanted to use your time and our time as efficiently as possible. Since we do have a case that's ready to go, we're going to go a little bit earlier, see if we can get a head start on today. A few things I see, at least from the list, we have a number of people who are very familiar and practicing here, a few that are not. So just a few housekeeping rules. I would note that we do have a few cases involving minor children. If there are any children that are involved in your case, your appeal today, do not identify them by name. Instead, use initials to preserve their anonymity. Also, I would strongly encourage you not to restate the facts. We've all worked very hard. We've talked about cases. We are very familiar with the cases, and we'd encourage you to identify the one or two legal issues that really the case turns on. If we find you sort of restating the facts as you've identified them in your brief, don't be surprised if we politely intervene and guide you in a different direction. So with that, why don't we call the first case, which is People of the State of Michigan versus Walker, 365-175. Mr. Bostic.
Morning, Your Honors. May it please the court, Nick Bostic on behalf of Mr. Walker, the appellant. I'm unopposed, so it'll be quick. You have a lot of briefing. The reason I think this case is important is because, in my humble opinion, the use of police officers as experts with agencies and the government being involved as a party is getting a bit out of hand. I think that is one of the most important issues in this case. Other than that, I will rest on my brief.
Counsel, am I correct? The drug profile testimony that you take issue with appears in the transcript. As I read it, it's really the testimony that appears on pages 311 to 312, quote, without a doubt, a dealer quantity.
Exactly, and blending in his anecdotal experience with the specific facts of the case to reach that opinion is, I think, where the major error occurred.
Okay. So if we agree with you that it's problematic, the difficulty I'm having with your case is that it seemed like defense counsel's theory was, let's focus on whether or not my client possessed. And so you'll see in closing that that's what the closing argument revolved around. And on day one, there was a stipulation to a lab report with the drugs and the weights associated with that. And so I guess even if I agree that this is really problematic and frustrating and not not true expertise, the prejudice seems to me a difficult obstacle to overcome in this case.
Well, there were the two elements, the element of quantity versus intent to deliver, but sure. Which of the three people in the truck possessed it? That was actually it. And then right. His opinion, the officer's opinion, brought in the amount of money in my client's pocket to bolster that opinion. So he brought my client into his opinion with that specific fact.
And without the expert testimony, wouldn't the dollar amount found on your client have come in through the other officers?
Well, it was really only relevant to the opinion. I mean, how much money he had in his pocket didn't really influence who of the three of them possessed it. They didn't even go into the amount of money on the others. I mean, I think there was, so it's the lack of aggressiveness of counsel, I think, that added to that problem. And that's what I'm getting at, is that the expert issue should have been handled before trial. And then there should have been much more done about clarifying who was where and who might have had control over that.
And when you say the expert issue should have been handled before trial, are you envisioning a Daubert that excludes this officer from the beginning, or?
Not necessarily a Daubert hearing, but you know, let's make the officer show that the anecdotal facts that he's relying on from his experience are actually reliable. Let's nail that down. And then, you know, we never have reports from these officers. They're noticed as experts, but we don't get a report like we would get from a scientific expert. Well, why not? Let's do that. If not, let's flesh it out before we get in front of the jury. So I think that there's a couple of problems with it's being used so frequently, but the other problem is we're not getting reports in advance. This is all being handled in front of the jury. I'll rest on my briefs unless there are other questions.
Any other questions? Nope. Okay, thank you very much. All right, the matter is submitted. You're up on 3?
I have 2. I have your third entry on your docket. That's my case as well.
All right, do you want to argue that one?
I'm ready.
Might as well just go right now. Okay, I'm going to call number 3, a little out of order. Accommodate Mr. Bostic. That's People of the State of Michigan versus Christopher J. Allen Bott Fleming. 365102.
Good morning, Your Honors. May it please the court, Nick Bostic on behalf of Mr. Bott Fleming, who is the appellant. An update, Your Honors, he was paroled in August of 2023. Our mailing to him came back. We've tried to call him with all the numbers we can find, all to no avail. So that being said, he is also due to be off of parole in August of this year. My issue 1 was obviously looking to set aside the plea. I'm no longer convinced that's in his best interest, but I can't consult with him at this point in time to find out. Issues 2, 3, and 4 deal with resentencing. Once again, I don't know that would be in his best interest. If that were successful, he would go back in front of the other judge and perhaps be put on probation again. So that's that. Now, the 5th issue is the attorney fee assessment. And then I found that anomaly in the record where there was an announcement that the discretionary assessments were going to be waived, but they still appeared on the judgment. I looked up on JIS yesterday. It still shows them as outstanding and that he's only paid about $18 and change toward them, I'm assuming from his prison account. So I would like to have that financial issue addressed, especially the attorney fee assessment, because as I briefed, I believe that once the indigent defense systems were put into place, that they determine the partial indigency. If they make that determination, 769.1 KB 5, I think, allows the court to then assess it, but not set the amount. So that's the position that I've taken in that brief on that issue.
As soon as his parole expires, that fee would also become moot, wouldn't it?
It's a judgment, so it's there.
Is it? I understand, but I mean, it's not exactly pursued. Have you ever seen the Michigan Department of Corrections pursue that?
Well, the Department of Corrections might violate someone if they really think they have the assets and they're not paying.
Right.
No, I've never seen it, but the court can enforce it.
Sure. No,
So,
that's true.
Right.
That's true.
Other than that, I will rest on the only brief that you have in this case.
Okay, thank you. Any questions?
Yeah, I have a question just to clarify. So at June 22nd, judge says, I'm not going to do any discretionary fines and fees, but that imposes attorney's fees. But were those the attorney's fees from the July 27th sentencing and then just brought forward? And if they are, does it matter to our analysis that it's not actually being imposed at the June 22nd? It's just kind of a copy paste from July?
No, I don't think it changes the analysis. The bench warrant fee obviously came later, but the community service assessment and the attorney fee assessment were with the original judgment. And then they were on paper continued, verbally they were waived. So I didn't catch that until the briefing.
Any other questions? All right, thank you very much.
Thank you, Your Honor.
Matter is submitted. Turning now to item number 2, which I believe all the parties are present. That is People versus State of Michigan versus Robinson, 365226. Mr. Way.
Good morning, Your Honor. May it please the court. Harold Gurwitz appearing on behalf of defendant appellant Todd Robinson. Mr. Robinson has asked this court to reverse the decision of the Jackson County Circuit Court that denied his motion for relief from the judgment in his case that was entered on November 16, 2012. In his case, not only was an indictment filed by a one-man grand juror sitting without authority based upon the one-man grand jury statutes, MCL 767.3 and 767.4, but the prosecutor also filed an information without there ever having been a preliminary examination. Mr. Robinson, excuse me, I should say that I'd like to reserve 5 minutes for rebuttal, please.
Right.
Mr. Robinson demanded a preliminary examination. He had a jury trial, was convicted, was sentenced, and he filed a motion for relief from judgment on July 20th, 2022, within a month after the decision by the Michigan Supreme Court in People versus Peeler, which held two things, one of which was that a one-man grand juror has no authority to file any charge. The court entered its order denying this motion on December 28th. Mr. Robinson asks for relief from the judgment because the one-man grand juror was without authority to file an indictment. The indictment, in the words of Peeler and Washington in an earlier civil case, Fox versus U of M Board of Regents, was void ab initio. These are defects in subject matter jurisdiction, and so therefore the limitations for filing a second motion for relief or judgment does not apply.
If we conclude that Peeler did not create a new rule, all right, I know that's contrary to your position, but I'm trying to work it out. In the event we disagree with you and we conclude that Peeler did not create a new rule, because there's some language, as you know, and from Peeler, that we're just applying statutory construction. This is what the law has always been. If we conclude it's not a new rule, how does that affect your argument? I mean, don't fight my hypothetical. Just assume for a moment, and I'm not saying that's how we're going to decide. I'm trying to understand how if we conclude it's not a new rule, how that affects your argument.
Well, I don't mean to fight your argument, but it is my position that it doesn't create a new rule.
I know, but if it does, what?
Oh,
how
if it does.
If it does,
Yes.
hypothetically, if it does, what happens to your argument?
I think then that the appropriate analysis is the one that is applied in Kennedy, and I submitted supplemental authority indicating that the court vacated this court's decision in Kennedy last Friday. But the analysis based upon the state standards for determining retroactivity as determined in Kennedy apply, and based upon those factors, the three factors that were reviewed by the court, it is something, it is a rule which is retroactively applied in this case. But I think that the reasons set forth in Peeler are compelling, that this is a matter of statutory interpretation, which has always been the law in the state of Michigan. Peeler.
Your argument, just to be clear, is that it's not a new rule, thus it applies retroactively.
That's absolutely right, Your Honor.
And so that gets at part of the subsequent 6,500 you need a retroactive case. And your argument is that you don't need to show good cause and prejudice because this is a jurisdictional issue?
That's exactly right. Washington, I think it's at page 131 in the opinion, makes clear that an exception to the limitations in 6,500 proceedings for jurisdiction applies when the court has no jurisdiction. In Washington, the circumstances were less compelling than here because what happened was there was an application for leave to appeal from this court to the Supreme Court that was on leave at the time the case was remanded and Mr. Washington was resentenced.
But
Here-
it seems like our Constitution controls the question of subject matter jurisdiction, which if I read your brief correctly, is the only form of jurisdictional concern you raise. It seems like issue with the bind over would get at personal jurisdiction and not subject matter jurisdiction if it's a jurisdictional question at all.
Well, there really was no bind over in this case at all.
Mhm.
The indictment was filed in circuit court, not in district court, and information was filed in the circuit court without there ever having been a preliminary examination.
I
Peeler,
think that's subject matter jurisdiction and not personal.
that's right.
Can you explain that a little bit for me?
Well, the subject matter jurisdiction is the authority of the court to proceed. Personal jurisdiction is the jurisdiction of the court to bind the individual party, the defendant, to the outcome of the case. And what happened here isn't that they picked the wrong statute or that there was a defect in the sentencing procedure, such as the case that the people have cited, the Cotton, the U.S. Supreme Court decision, where there was a defect in the indictment. Here, the indictment was without authority from the very beginning.
So you said a moment ago that personal jurisdiction is the authority of the court to proceed over the person. I agree.
That's right.
And then you said subject matter jurisdiction is the authority of the court to proceed. It feels like you left something up. Proceed over what? Or just proceed?
Over the case. Over the case, not over the statute.
What's the
Here,
difference between over the case and over the person?
the difference is the authority of the charging process. Here, a judge was appointed as a prosecutor, which is without precedent, I think, in our jurisprudence, except for these statutes that were enacted in 1917. The judge, as Justice McCormick described it, was acting as a Star Chamber comeback when he filed the charge. The statutes, as enacted in 1917, clearly provide only for an investigatory procedure, not a charging procedure. It never did. There was a report, which I've cited, of the State Bar Special Committee that was appointed to investigate and make recommendations to the State Bar on what actions to take in light of criticism that had been made public in the media. And as a result of a decision by the U.S. Supreme Court in Ray Oliver, which found a due process violation, the procedure used by a one-man grand juror to hold a witness in secret contempt. That's not an issue here, but in passing, the court found that there was a substantial problem with the procedures used in that case. Peeler outlined a number of additional reasons why the statute provides no authority. The argument
So I think we all agree that, I don't think anyone can disagree that this procedure was unlawful, especially following Peeler. I think the hangup, at least for me, is what makes a system that was created by statute, the preliminary examination here in Michigan, what triggers subject matter jurisdiction in this error? So the same problem that existed in Peeler exists here, no question. A judge acted like a prosecutor. It's contrary to statute, but in violating a statute, what triggers subject matter jurisdiction?
Your Honor, it is not just a violation of a statute. I think that
Under Peeler, it is, though. Peeler doesn't make a constitutional analysis, nor does it reference jurisdiction at all, which is why I'm trying to figure out why a violation of this statute triggers jurisdiction. So that's
What
I
I'm
need
trying to
know.
explain it is certainly a violation of the statute, but it is not just a violation of the statute. And a very compelling example is the way in which the circuit court resolved the remand in Peeler back to the circuit court when it found that the defect made the indictment void ab initio. From the very beginning, the court had no jurisdiction to proceed in any manner except to dismiss. And that's what the cases have said. That's essentially what the Fox decision, which we've cited, says in the context of a civil case.
But that was on direct appeal versus collateral appeal after the judgment's been made final, which is what you have.
That's right. Washington makes absolutely clear that a court has an absolute duty to take notice of a lack of jurisdiction at any point in the proceedings on a case. And that includes collateral appeal. In Peeler, not only did Judge Kelly in the Genesee County Circuit Court find that the case was without jurisdiction, but she also denied the prosecution's motion that they made to send the case then to the district court for a preliminary examination. That issue was raised by the Attorney General's office on an application to leave to the Michigan Supreme Court in every one of the 7 cases, and then the 8th one, including former Governor Snyder. The court dismissed, did not grant those applications because under the court rule, it said that the questions presented were so unsubstantial as to present nothing for review. The Attorney General's office then asked the Supreme Court to grant leave, and that was denied. I think that those cases make absolutely clear that this is a defect in the court's ability to take any action in a case. It's just not a matter of personal jurisdiction. In Kennedy, the defendant appellant argued that it was a matter of personal jurisdiction. And the court found that the position he had taken wasn't really so clear, but on the basis of personal jurisdiction, denied relief. There was an application for leave to appeal filed, and I've read through those briefs, and Mr. Kennedy argued to the Supreme Court that this really is a matter of subject matter jurisdiction. That is exactly what is presented by this kind of a defect. I should say that there is a subsidiary issue that was raised by Lyons to the Michigan Supreme Court on whether or not the placement of prosecutorial authority in the role of a judge creates a constitutional problem. The court said they didn't have to address that because they found that without any question that there was never any authority to bring a charge. That is consistent with what the statute has said since 1917. It's what the bar found. And in fact, in 1949, the legislature amended the one-man grand jury statute to increase the number of judges participating in this process to 3 and granted the authority to charge. 2 years later, it revoked that authority, and I think that is an additional reason.
Is interesting here because there's case law that talks about the court's authority being an exercise of jurisdiction versus jurisdictional in and of itself. And so that's what I'm struggling with. Are we talking about an improper exercise of authority, or are we talking about a complete lack of jurisdiction? And if it's the latter, what makes it so other than the actions taken by the trial court, which isn't controlling on this court?
It is not the act of exercising jurisdiction that is the primary fault here, but it is the establishment of jurisdiction that was never given. This would have been no different than the prosecutor filing a charge in the circuit court and the defendant going to trial without there having ever been any preliminary process which presented the case to the court, either in the form of a complaint or information or indictment. It is just, it's an anomaly in the system. There is no other mechanism in our jurisprudence of which I'm aware that allows a case to begin in this fashion. It happened as a unique circumstance when the legislature enacted it in 1917. And it hasn't been exercised very often, as the court found, as a reason why there can be retroactive application. And it shouldn't have happened in this case. And that's, I think, what Peeler requires,
Counsel,
the Supreme Court decision requires.
If we agree with the first part of your argument, what's your response to the counter argument that, okay, acknowledging that there were not just defects, but significant defects in the grand jury proceeding, how are they not cured by a fair trial?
Yes, Your Honor, with all due respect, I would phrase the question a little bit differently.
You can go ahead and do that, but then answer the question that I asked.
And I will. I'll do that to answer the question. It's not a question of defects in the proceedings. It is the fundamental problem that the court did not have jurisdiction in order to conduct the proceedings. It's not like the circumstance that's discussed in People versus Hall, where there was a problem in the charging process that the court found to have been rectified because there was a trial and a finding of guilt. That's not the circumstance where the court has no authority to begin the case. The adjudication itself is without a basis. It was without a root in the law in order to make it proper. This is not a defect in proceedings, but rather with the authority of the court to begin at all. I hope I answered your question.
I don't think so. The question that I'm getting at is, I mean, you like Hall that both sides address, where you have problems with the grand jury process. Those problems affect whether or not a case should have been brought in the first place, whether or not it should have been in front of the court in the first place. But once it's there, if you have a fair trial in front of a jury or a fair trial in front of the bench, how does that not then solve the question of, well, should these charges have been brought in the first place? If it's proof beyond a reasonable doubt, then the answer seems to be yes. How do you respond to that?
Yes, I think I would agree. If the answer that you arrive at is that it was there, and so why isn't it solved, is that that's okay, relying upon People versus Hall, then that's where you get to. But my position is that it shouldn't have been there at all. It is not the way in which the proceeding was conducted, but rather that it was conducted, that the court acted as if it had jurisdiction over a case. And I've cited several cases, I think, which support that in addition to Peeler. One is People versus Curtis, where the court acts as if it has authority, but it doesn't. It doesn't have authority to do anything, according to Fox versus Board of Regents, except to dismiss. Each one of those actions thereafter, whether it's denying the motion that Mr. Robinson made for a preliminary examination, conducting his trial, sentencing him to life in prison, and denying his motion for relief for judgment that was made after Peeler. Each of those, to the extent that, well, it could have granted his motion. Let me amend what I just said, but each of those other preliminary steps was done without authority in the case. It's not a matter of the way the procedure was conducted, but rather that it was conducted at all.
Thank you.
Okay, thank you very much. You got a few minutes for a rebuttal. Thank you.
Thank you.
Wait.
Good morning. May it please the court, Matt Wade, Jackson County Prosecutor's Office, on behalf of the people. A lot of my notes, I think, will address some of the questions that you all have raised. And so I'm not going to, unless the court would like me to, I'm not going to get too much into the retroactivity analysis itself. I know it's still kind of pending. I know, Judge Hood, that you're on the Kennedy panel, and so, but I am happy to answer any questions regarding that. I did want to.
You agree that it's not a new rule and it's probably retroactive?
Looking at the Peeler opinion in a little more detail, I think that's probably accurate. I know there's another case pending for a different panel that indicated kind of the same thing. So I'm not going to get too much into that issue. I do want to get into just first the court rule. And I didn't address it too much in my brief, but MCR 6.508 sub D and the Kennedy opinion, while the Supreme Court order was a little unclear to me. I'm not sure whether it's vacated in full or in part, but in any case, I think it provides a good roadmap. Subsection 2 of that statute prevents a court from granting a relief unless the motion alleges grounds for relief which were decided against the defendant in a prior appeal or proceeding under this subchapter. Defendant raised the Peeler issue in the trial court at the trial court level. He did not raise it in his direct appeal nor in his initial motion for relief from judgment. So subsection 2 does not apply to defendant. In the direct appeal, I don't know if I noted it in my file, but he did appeal his conviction. And that's docket number 317282 of this court. Subsection 3 is obviously broader, allows for other grounds other than jurisdictional defects, which could have been raised previously, unless the defendant shows good cause and actual prejudice. Defendant, like in Kennedy, has not even really attempted to argue good cause or actual prejudice. I don't think there's good cause because this is probably a more unusual circumstance where this issue was actually raised in the trial court.
Sorry, that language you cited, isn't there a carve out for jurisdictional issues?
Yes, it says allows for other grounds other than jurisdictional defects. And so I'll get to that after.
Okay.
So, but I just want to point out, he has not argued good cause or actual prejudice. Certainly, I think he cannot show actual prejudice given the
But you
abundance
agree
of.
he doesn't have to if the problem's jurisdictional?
I would. And so
Okay.
that's kind of my ultimate point is that he has to show subject matter jurisdiction issue. And defendant simply cannot show that. I did want to just quickly address defendant attached some lower court documents from the Peeler case, reference them today. Those are not part of this record, so I'd ask that the court not consider those in forming its decision. As to the subject matter jurisdiction issue more generally, I won't recite all the cases I did in my brief, but it's clear that the case law across the country has held that a defect in the indictment process does not affect subject matter jurisdiction. And I certainly agree with the panel's questions or implications that what defendant really is arguing is personal jurisdiction, not subject matter jurisdiction. And I quoted our Supreme Court in a case on page 3 of my brief, and where our Supreme Court makes pretty clear that subject matter jurisdiction is not the right of a power to exercise judicial, or not the right of a court to exercise judicial power over the particular case before. And that goes directly to your question, Judge Young. Rather, it's a judicial power to preside over a certain class of cases. In this case, the class of cases we're talking about are criminal felonies. And the circuit court clearly has subject matter jurisdiction over that under loan. And there's a footnote in loan that cites to, I think, 2 portions of our Constitution, as well as several different statutes. And I think the analysis really begins and ends there. But I did just want to make a couple other points. I think when you read Peeler, it's clear that the defects in the indictment and the preliminary exam process are procedural and statutory in nature. There's no constitutional right to a preliminary exam. The court was very clear that it was not deciding it on constitutional grounds, as you indicated, Judge Young, and on specifically on page 400 of that opinion, our Supreme Court calls it a statutory holding. And defendant has not really raised any constitutional issue before this court. So I don't think that that's proper. And that gets me to kind of my last point. Our Supreme Court issued an opinion, I think it was Tuesday, in People v. Scott, regarding subject matter jurisdiction and interlocutory appeals versus the Washington case. And the Scott opinion, when I read it, it makes clear that procedural defects like we have here do not implicate jurisdiction. And the important quote I want to highlight is on the bottom of page 24 of the slip opinion. which says interlocutory appeals simply do not implicate our Constitution and therefore remain outside the scope of jurisdictional concern. So procedural, so non-constitutional defects remain outside of the scope of judicial or jurisdictional concern. That's exactly what we have here. Maybe if there's a case where a defendant raises a constitutional concern and addresses Peeler in that context, maybe it's different. I don't think so. But given that there are no constitutional challenges here, there's just a challenge to subject matter jurisdiction. And I don't think defendant has shown, even ignoring the constitutional argument, the subject matter jurisdiction of the circuit court is, let me rephrase that. A circuit court has subject matter jurisdiction over any cases not prohibited by law, is what the Constitution and our statutes say.
Including, as relevant for this case, felonies.
Right, criminal felonies. And say in the Washington case, there wasn't subject matter jurisdiction because there's a court rule specifically saying that there wasn't there's not jurisdiction when there's a direct appeal and there's constitutional implications to that. So for all those reasons, for the reasons that we state in the brief, even if the trial court was wrong on the retroactivity analysis, they were certainly correct in terms of prejudice. The subject matter jurisdiction wasn't raised at the trial court level, but obviously it can be raised at any time. It's our position that there's clearly no subject matter jurisdictional issue. So we would ask the court to affirm the denial of defendant's motion for relief from judgment. And other than that, I'm happy to answer any questions the court may have.
I think we're all set. Thank you.
Thank you very much.
As I have argued in my reply brief, and I think in my principal brief as well, the cases that the people have relied upon to suggest that there is a procedural defect make it clear that this is not that the defect in this case with subject matter jurisdiction here, which I claim is present, is not the same as it is there. And I refer particularly to Cotton, which was an issue with whether or not the indictment contained sufficient allegations in order to impose a sentence enhancement in that case, and a whole string of cases from state courts that stand for the same principle. This is different because this deals with whether or not the court, in fact, had authority ab initio, as Judge Kelly said, and as Washington said, to take action to file an indictment in the very first place. Certainly the indictment refers to, it purports to allege a criminal violation. So it presents that aspect of concern here that this matter concerns a class of cases, but it's not a case. It's not a case. And what makes that, I think, also abundantly clear is the language that the court used in Washington. And that case presented a problem which is less fundamental than this. In Washington, clearly, the court, there was a charge that was filed in the district court. There was proceedings in the trial court and the defendant was found guilty. The court used the terms vest, that jurisdiction vested, and it divested. So in those terms, the charge, the subject matter jurisdiction vested at the time the charges were filed, but it found that when the matter was on leave to appeal to the Supreme Court, jurisdiction divested. It's something that could be affected in that way. And those are the terms, I think, that the Scott case refers to in the opinion that was issued this week. Those are not the same. This is a different circumstance in which there was never a vesting of jurisdiction in the court at the very beginning of the proceedings. It couldn't happen because the judge acted outside of the scope of any authority he had based upon the Constitution or statutes of this case to file an indictment. Peeler makes absolutely clear that the statute provides for investigatory authority and not charging authority. There is no other basis from which the judge could have obtained any specific authority to act as in the capacity as a prosecutor to file charges. And it's for those reasons then that we maintain that there was no jurisdiction of an issue. And the circuit court erred by denying the motion for relief from judgment, which Mr. Robinson filed pro se and made the same argument essentially that I'm making now. It's for all of those reasons that on his behalf, I ask this court to remand with directions that his motion be granted.
This is a subsequent 6,500 or his first?
It's a subsequent. There
Okay.
was one filed in 2018 arguing lack of evidence and ineffective assistance in procedural errors. There was a remand at some point for an evidentiary hearing where there was found to be a substantial problem with the prosecution failing to provide information about an immunity offer that was presented to a key witness at the trial. In spite of that, the judge denied that motion at that time. So procedurally, this is the second motion.
You said a moment ago that raising the same issues that I'm raising now. Was this issue ever raised before in a prior appeal?
No,
I didn't think so.
no, it was not raised on a direct appeal. It was not raised until Mr. Robinson filed his pro se
I
motion.
misunderstood you then. Okay.
Yeah, in
All right.
July of 2022.
All right. Thank you.
You're welcome. Thank you very much.
All right. Matter submitted. Thank you both. Turning now to item number 4, People of the State of Michigan versus Nicole, 364695.
Good morning, Your Honors. Michael Ferrone on behalf of Mr. Nicole. You should have before you an amended brief on appeal. We did amend the original brief on appeal.
1 second. We're gonna let. I just want to make sure we can hear you.
Right.
All right, go right ahead. Sorry.
No, I appreciate it. I've been fighting a cold this week, so if my voice doesn't, let me know if I need to speak up or if there's I apologize for that. So, this case arises from a fleeing and eluding, resisting arrest. It's kind of nice as a defense attorney to have a case where there's not a victim, really. The officer, there was a resisting arrest, but the testimony as defendant just kind of didn't comply, didn't really actively resist. But from this case, I think there's an interesting issue embedded within it, which is whether, maybe embedded within it, which is whether structural error can be waived. I would actually, my argument, I think in the brief and what I want to focus on today is that.
Structural error in terms of the jury instruction.
Correct.
Okay.
I would argue there was no waiver. This isn't a situation where the trial judge said, I forgot to read the offense instruction. Is that okay? Do you want me to bring them back? And then the defense attorney said, no, just leave it alone. That would be a waiver. Here, all we have is the trial judge said, quote, are you okay with me not? No, I apologize, of the other way around. Here, the trial judge said, quote, any issues with the jury instructions? Just sort of a generic question. And both attorneys said no. So if you look at the cases the prosecution cites, none of them actually involve a failure to instruct on the offense elements. Kowalski involved, at least not a complete failure. Kowalski involved a failure to properly give an instruction on costing a minor. I mean, the wording of it, but the instruction was given. Chapo involved a defense instruction. Matuzik, same thing. It didn't involve a complete failure to give a instruction on the offense. Luth involved a defense instruction, and Miller involved a question of whether time was an element of identity theft. So none of them involved a failure to simply give that instruction on the offense as part of the overall closing instructions.
Did the jury get the
They did.
correct written copy?
They did. I think that gets to the heart of it. I think, you know, at first glance, I think that's their best argument because, well, I say they did. I mean, it's not in the record. It's that I can recall, but I believe they did. The prosecutions indicated that they did. They've provided those. I didn't receive those until their responsive brief. I believe I take them at their word at that they
And
did get those
also received the
instructions.
preliminary instruction.
They did.
The elements, the correct elements in the preliminary instruction.
They did. They did. And part of the original instructions was the offense element that's at issue. However, and I think that's their best argument. However, I think it still fails as an argument. And that brings us to People v. Traver, where our Supreme Court held that oral instructions are required. Written instructions aren't sufficient. And that, I don't know if we discussed this in the brief, that's pretty much the rule throughout the country, that you can't cure the failure to give an oral instruction by pointing to the written instructions. So that's the holding in Traver. And I think the reason for that, and I'll probably end up insulting everybody in the room and everybody in the country, but I think my opinion, so it's not stated in Traver, the reason for that, or one of the reasons should be, is people don't read. I mean, I question how often during jury deliberations does a jury say, you know, we're struggling over something. The judge gave us these written instructions. Let's read them and see if the answers are there. I'm sure that happens, but I think that's probably unusual because people don't read. They
I think some people could
Some-
retain
I mean,
more. I mean, I don't know about you, but I remember more from what I read than what I hear, especially at the end of a trial and people are droning on with, you know, the judge is droning on. But I don't want to derail your argument, but I think some of the members of this panel are more interested in the issue dealing with the prosecutor's cross-examination and the issue of the outstanding warrants,
okay.
the
Sure.
cross-examination, the introduction of that evidence, and the issue of either prosecutorial misconduct or ineffective assistance of counsel.
Okay.
So I just want to,
Sure. No, I appreciate that.
I want you to go full steam on
No.
those issues too.
No, I appreciate that. That's pretty much, that's all I had to say in issue one. People, you know, obviously this court reads, there are people that do read. This court reads all the time. That's all the court does is read. But in general, I think people are inclined to go by what they hear now. So issue two, regarding issue two, the jury was told, as you go through the trial and the questioning, first there was the audio video recording that was given to the jury. And in it, Nicole states, quote, "Nice seeing you again," to an officer. And if we look at the transcript, from that, the prosecutor really launched into a discussion of how Deputy Ilhander knew Nicole and knew him from a arrest warrant for domestic violence and aggravated assault. And then, so that's error one. Then error two arises in the prosecution's cross-examination of Deputy Ilhander during the defense case. And in that, the jury learns that the defendant fails to appear for court. And that prompts the prosecutor to turn to the witness and say, you know, asks the witness, quote, "That's what he does, basically. He's a criminal. He doesn't show up for court." Now, I don't think
That's what the prosecutor said.
that's what the prosecutor said to Deputy Ilhander. And so how does all this end up in front of the jury? As I understand the prosecution's argument, it is that the defense questioned the timing of when the police learned of the warrant. But I'll confess, maybe I'm missing something. I don't follow that argument. Because
Even if they're right? Even if the trial, the defense, I suppose, opens the door to asking about the warrants themselves, right? After you've already had the pretrial motion that says the warrants aren't going to come in unless the validity is challenged. Not sure that that's what happens here, but assuming for the sake of argument, that is what happens. Saying this is what Gary Nickel does, isn't it? He's a criminal who doesn't show up for court, correct? And at that point, that's not 404B, that's 404A. That's character evidence.
Right. And if you look at the trial, it was a very contentious trial. I don't know that I mentioned this in the brief. I didn't make a big issue of it, but there was a lot of back and forth between the prosecutor and the trial attorney. And
It's clear in the
prosecutors,
transcript.
accusing the trial attorney of ethical, all this. and a motion, I guess, I'm trying to say, which was inappropriate. Prosecutor should have pulled back,
Inexperience.
maybe inexperience on the part of, yeah, certainly could be on the part of, I don't really know the prosecutor, could be inexperience. I mean, I'm sure they're very big. I mean, I get it. People make mistakes, but it's a huge mistake.
Same prosecutor asked for a life sentence in this case.
Oh, right, okay. A life sentence, so there we go. So there's something going on emotionally, which is causing some lines to be crossed, which shouldn't have been. And, you know, I would back up and say that, so what? What if the defense did question the timing of when the police learned about the warrant? Implicit in that is that they accepted there was a warrant. So I don't think that would even justify, even under that theory, I don't think that justifies bringing in all these details. I don't think it.
I'm interested to hear from you about what, in your judgment, what was permissible and at what moment did it cross the line? What is your position in terms of, had the prosecution introduced in front of the jury that there, through testimony, that there were one or more warrants out for his arrest and that's why we pulled him over? Would that be admissible?
The existence of a warrant?
Yes.
Uh,
To explain why we pulled him over.
Yes, yes, I'm not.
I agree. I mean, because, I mean, for the crime of fleeing and eluding, there has to be a basis to make the stop.
Right,
I think it's a lawful basis or a valid, I can't remember what the statute says. That's an element of the crime.
right.
So evidence that there was an outstanding warrant, you agree, would be admissible. It's when the prosecutor crossed the line and dove into this circumstances of those outstanding warrants and everything past that point where he crossed the line. Is that your position?
Yes, but in particular because there was, I think there was a pretrial ruling where the judge.
Which wasn't terribly clear either. I mean, I read that to begin to say it was the certified copies are not going to be admitted unless the validity of the warrants are to be admissible. And then there was also some language, well, of course, that there were, I'm paraphrasing, something like to the language like, well, the fact that there were warrants out for his arrest, that's not the problem. It's what's behind the warrants that's the problem. At least that was my takeaway from the court's order.
Yeah, maybe I agree. It wasn't a perfectly clear ruling, and maybe I'm incorrect, but that's how I understood the pretrial ruling, which that you could, as the prosecutor, you can mention that there was a warrant. You can't get into the details of it.
So to that end, if the warrant can come in and we're clear on that, what about the details on the face of the warrant? The fact that one is for breaking and entering with intent or contempt of court for failing to appear on breaking and entering with intent, the other one for domestic violence. Does the warrant have to be redacted, or is the fact that now the jury sees, oh, well, he's charged with domestic violence and he's charged with breaking and entering with intent?
I don't think the warrant even had to be admitted. I'm not even sure why the paper document had, I don't recall seeing that in other trials where they submit the actual warrant. I don't think they need to even get in that. If the defense, and I guess it's at some level, at some point, the defense did, question, when did you learn of the warrant, and did make that in? Okay, that could be resolved through testimony. That's not answered in the written warrant anyways. So I don't understand how the written warrant really addressed anything that the defense was raising. I don't think it had to be admitted. All those details could have been left out. The details were prejudicial because you have a resisting arrest charge where it's a debatable, arguable resisting arrest. The claim wasn't that he struck the officer or anything. It's just that he didn't comply quick enough. And then the jury learns, oh, he also doesn't show up in court. Well, that fits right in with resisting arrest. He doesn't comply with the judicial system. He domestic violence. So
Oh, I mean, you're getting right to it. I was just gonna say, so on problematic trial A, the existence of the warrants comes in. Hey, he had active warrants and I pulled him over, and and then the rest is just history. But in problematic actual trial, the circumstances of the warrants come in and so you were just getting into what my question was, which is why is that enough? If we understand that the unproblematic trial still has the existence of the warrants there in front of the jury, why is the circumstances of the warrants enough here to rise to the level of prejudice?
Yeah, so, yeah, it's almost, it couldn't be drafted better for me. I mean, he's charged with fleeing and eluding, so disobeying police, and with resisting arrest, disobeying police, disobeying authorities, disobeying the judicial system, and then the jury's told he fails to appear in court. And they're also told he engages in, domestic violence, or may engage, there were warrants, violence, aggravated assault, fails to appear in court. That's just like fleeing and eluding, just like resisting arrest. That's disobeying the judicial system. And then the prosecution
Connected the dots.
brings it all together by turning to the deputy handler and saying, that's basically, that's what he does, basically. He's a criminal. He doesn't show up for court. I mean, that fits, that brings it all
This
together.
may play into the prejudice, but this is something that wasn't briefed, but it may or may not be relevant. What was the theory at trial? Was it, I wasn't the guy driving? Was it failure of proof? What was the theory at
Yeah.
trial?
The
It wasn't
defense theory was that it wasn't Mr. Nicole in the car, and that, whoever was driving, or he may have been in the car. He may have been in the car, but
wasn't
he wasn't driving it.
Got it.
Whoever was driving drove around the barn. And that did happen. The police did stop at some point and waited, and that
It was identity.
truck, exactly, drove around the barn. And the idea was he then popped up afterwards when the truck stopped. I don't know if I need to address issue 3. Hopefully not, but it's a.
Well, you have plenty of time.
Well, it's an interesting, if the court gets to issue 3, obviously I'm asking the court to remand for a new trial.
One
I'm
last
sorry.
question
Sure,
related to the second issue. Looking for cases assessing prejudice in the context of a 404A violation like we have here, where a prosecutor says he's just generally a criminal. This is what he does. Not pointing to 404B analysis of prejudice, or the 403 analysis within Vandervliet, but specifically a 404A violation like this. I just haven't been able to find anything. Are you aware of, is there a different framework, or can we just crib the 404B analysis and map it on the 404A? How do we assess prejudice for something like this?
That's, I agree, for every 404A issue raised, I think probably 100 404B issues raised. There aren't as many cases. I had one, which was, I could think of one, I'm sure they talk about prejudice, People v. Bynum, BYNUM, Michigan Supreme Court case a few years back. I believe that might be helpful. That's a 404A case.
That's a character for aggression case.
Yes, yeah, not exactly on point.
I'm saying for a 404A1 case where it's just
Character.
character,
Yeah.
not a carve out for character evidence.
No, I apologize. I could.
That's fine. It's somewhat tangential to the issues that you've briefed, but
I'm hoping that the prejudice here is so obvious because the character that was being attributed to the defendant just maps perfectly onto the charges. That so issue 3. Obviously, I'm hopeful that the court won't get to issue 3, but if the court does, that is, again, I think that's really. I'm not trying to sound sarcastic. I think I'm in a head's a little cloudy this morning, so maybe I'm coming across as sarcastic. I'm not trying to when I say that language that the court gives is perfectly scripted to violate the Fifth Amendment. And I don't believe the trial judge, obviously the trial judge didn't do it on purpose. The trial judge wasn't trying to violate any rights. But people make mistakes, judges make mistakes, everyone makes mistakes. And she did say to the defendant at sentencing. So the defendant, Mr. Nicole, he doesn't testify at trial and he doesn't say anything at sentencing. He does speak up at other points in the proceedings. He's capable of doing that, but he doesn't testify at either of those two proceedings. And his attorney speaks on his behalf, and she says, he kind of, to some degree, blames society for not helping Nicole enough. And the judge reacts to that and says, quote, the only one that you completed treatment programs successfully was the one in 2010. So I don't think it's appropriate to say nobody took the time. Now that's perfectly, I think that's legitimate comment by the trial judge. It's responsive to what trial counsel was arguing. But then the judge says, and I don't think it's appropriate to say, for you to say that you maintain your innocence, or for your attorney to say it. That is a plain violation of the Fifth Amendment right to silence at sentencing, the right to maintain your innocence at trial. It maps perfectly onto People v. Conley. It doesn't fit People v. Draper, because in Draper, and the prosecution acknowledges this in their brief, if you look at their brief, the language is in there. In Draper, the trial court, quote, stated on the record that it recognized defendant's right to maintain his innocence throughout the trial and forever. Well, the trial judge in our case did the opposite. I mean, she said, I don't think it's appropriate for you to maintain your innocence, or for your attorney. Now, and I'll end by saying what the judge says after that, because I think I have that in bold and quotes. I actually think what the trial judge said after that's probably appropriate. I'm not really attacking that, where the judge says, I saw the video of the entire incident and the jury's verdict was completely 100% on point. The judge is allowed to agree with the jury, and that it's that middle sentence there, which requires a resentencing. Hopefully, however, we don't have to do that when we go back. Defendant goes back for retrial, and maybe they resolve it. Thank you.
Good morning. Good morning. May it please the court, Jasmine Davis, appearing on behalf of the people. This court should affirm Nichols' convictions and sentences. Since defense counsel just talked about issue 3, I'll just briefly touch on it. I would just draw this court's attention to the 3-pronged test from People versus Conley, and that is for a sentence to be based on a defendant's refusal to admit guilt. This court looks to the 3 factors in People versus Conley, and that's 1, that the defendant maintained his innocence after conviction, 2, that the judge attempted to get the defendant to admit guilt, and 3, that there was the appearance that had the defendant affirmatively admitted his guilt, his sentence would not be so severe. So obviously we do have Nichols maintaining his innocence, so that prong is satisfied, but never did this judge attempt to get him to admit his guilt or say anything of the nature that had you just said you were guilty, I would have given you a lighter sentence. So those 2 prongs are not satisfied. And you have to view the judge's sentence in context. When they're saying, I don't think it's appropriate for you to say that you maintain your innocence, or for your attorney to say it, the judge is clearly just commenting on the strength of the prosecution's evidence in the case. And you can see that from the statement that follows when the judge says, I saw the video of the entire incident and the jury's verdict was completely 100% on point.
How about the warrants?
The warrants. Okay. A part of me does feel like I don't know exactly why it was necessary to introduce written copies of the bench warrants. I will say they're relevant because they do establish the elements of second-degree fleeing and eluding and police R&O, which require that the officers are acting lawfully, like gave a lawful command or made a lawful pursuit. So it's not like they're totally irrelevant. I would focus on the lack of prejudice stemming from written copies of the warrants, because a domestic violence charge and a breaking and entering, the elements of those crimes have nothing to do with fleeing and eluding or police officer resisting and obstructing.
What about failure to appear on both of those warrants? Because both were one was for failure to appear, one was contempt for failure to appear.
Yes, Your Honor. I still don't think that, so the prosecutor did make that one statement, like Nichols a criminal, he fails to appear for court, but that's one statement. It wasn't used in either opening or closing, like as like propensity. Like, this is Gary Nichols, you should convict him because he's a criminal who doesn't show up for court. And here are these warrants that show he doesn't show up for court. That wasn't what happened. Like, the prosecutor didn't base the case on the fact that he's previously failed to appear. I think what it was is that Deputy E. Honda recognized Nickel as he was driving by. And Nickel wasn't committing any traffic violations. He was abiding the law. But yet E. Honda decided to perform this file check on Nickel. And what the defense was doing was the defense was questioning like the timing of like, oh, like, you know, you were basically were trying to pursue him before you even knew he had a warrant. So it was seeming to me just from reading the transcript, the defense is trying to make an argument that this is some kind of like pretextual stop, like he just saw Nickel and decided to pursue him. And so what the prosecution is they had elicited testimony that Deputy E. Honda kind of knew that Nickel had a warrant. When he saw Nickel and recognized him, he kind of knew Nickel had previously failed to appear for court. And that's why he decided to perform the file check. And then it verified, oh yes, he has a warrant. And then he pursued him. I think that's why there was so much emphasis on this failure to appear, if that makes sense.
Yeah, so you're conceding that it was error, but you're challenging the prejudice.
Yes, exactly. The prosecutor absolutely should not have said he's a criminal. He failed to appear for court, but the prejudice isn't there. And then I'll also rely on the arguments that I made in my brief, which were that
I'm sorry, and your point why it's not prejudice not there is because it wasn't mentioned in opening, wasn't mentioned in closing. It was an improper statement made by the prosecution that wasn't repeated.
Yes, exactly. It was like one statement and it wasn't like the basis of the prosecutor's argument to the jury. It was one question on an examination of Deputy E. Honda, which wasn't really a question. It was kind of more of a statement.
Yeah, right.
And I would say that the prejudice isn't there as well because of the trial court's jury instructions. The jurors were instructed that the lawyer's statements and arguments are not evidence.
But that was testimony. It ends with them saying, so he's a criminal, correct? And then the response is correct. That's not the lawyer's statement.
Okay, true, but the jury already knew that he was a criminal just from the mere fact that he had warrants.
That doesn't make you a criminal to have a warrant.
Okay. Well,
He's charged with something, right? Or maybe he failed to show up at court.
well, they also knew he was a criminal because Deputy E. Honda testified that he previously arrested Nickel and he knew him from a prior arrest. And that's part of the reason why he felt in danger when they were outside the barn because he's previously interacted with this guy.
Seems to me that kind of feeds into your opponent's argument that this is other stuff that doesn't really have anything to do with whether or not in this instance, he's resisting. In this instance, he's fleeing, and whether or not there's a lawful arrest. I guess I'm curious, as part of your prejudice analysis, it seems to me that none of the 404A evidence and none of the 404B evidence had a limiting instruction. How does that affect how we weigh the jury's following instructions? In addition to disregarding statements from the attorneys, they're told to consider all the evidence. And if there's no limiting instruction, no objection to the majority of this, how does that affect how we assess prejudice here?
Well, I mean, I guess I would just say that it's clear that the warrant evidence was being brought in to explain like how this case even transpired. I feel like it should have been clear to the jury, like we're not convicting Nickel because he has these warrants. It's just that explains why the deputies started pursuing him. That explains why Deputy E. Honda would even recognize Nickel. It's like necessary context for everything that happened, because for them just to start pursuing him and he hadn't committed any traffic violations or obvious crimes, then that's not okay. So the jury needs to know like why he's being pursued, why they're stopping him. And I feel like even without an instruction, like you shouldn't consider these, other bad acts as proof of guilt. I feel like it's just very obvious that the warrants and everything was just brought in to like explain the entire story to the jury. There was a lot of evidence that,
I just have a clarifying question. So when
Yes.
Judge Cameron asked if you agree that the admission of the warrants was error, I thought you said yes. And now it sounds like you're saying that they were necessary context, which is reflected in your brief, and that they were relevant to complete the story. So do you think their admission was error, or do you think, I understand that the hook here, the strong argument that you led with was prejudice, but do you even think that the admission was error or no?
I don't think the admission of the fact that Nickel had warrants was error. I don't know 100% why it was necessary to admit the written copies, just to combat the argument about the timing per se. But I will say, even though they were admitted, they weren't prejudicial. That's my argument. But I would say like it's necessary, like the warrant evidence was necessary because like the jury heard the deputy E. Honda recognize Nickel as he drove by. He performed a file check, even though he was observing the speed limit. He previously fought with Deputy E. Honda. They saw the video where Nickel says, "Nice seeing you again." Deputy E. Honda testified that he believed Nickel was a dangerous person. So it's necessary, like the evidence that he was previously arrested by Deputy E. Honda, that he had these active warrants. It's all necessary context because otherwise it just wouldn't make sense as to why police officers would just start pursuing somebody. And the jury could have just said, that's not fair that they would just start pursuing somebody with no legal basis to, and acquitted him on that basis. So it's necessary for the prosecutor to show like, no, he has these warrants and there was a basis for the deputies to do what they did. I don't think that's unfairly prejudicial, especially because the defense knew, at least the defense knew that this type of evidence was coming in. From the motion in limine hearing, it was apparent that the prosecutor intended to introduce evidence that Nickel had warrants and was intending to introduce the written copies if there was some issue raised with the legitimacy of the traffic stop. So the defense could like prepare to combat that information at trial. And then
the way I addressed it with Mr. Ferrone is this. So it sounds like ideal trial A is what Judge Cameron offered, which is to say this person has warrants and that's why they were stopped. But what actually happened is this person has warrants, they're for assaultive behavior, this person's a criminal, they don't show up to court. And so I don't think anyone disagrees that some aspect of the existence of the warrants was relevant. But how does all the extra, the saying this person's a criminal and that being admitted as evidence for the jury to consider, because it's the context of a yes or no question. The police officers are questioned about the aggravated assault, domestic violence. And so how does all of that not prejudice Mr. Nickel?
I would say the question is it unfairly prejudicial? And I would say no, because again, like domestic violence and breaking and entering, it just doesn't have anything to do with the charged offenses. I could see if this was another fleeing and eluding and the jury could conclude, oh, he's fled and eluded before and now he's doing it again. But this is totally unrelated. And as for the failure to appear, I mean, he's there now. I mean, it's also, he's not charged with failure to appear in this case. So I would just say like, it just didn't rise to the level of unfair prejudice because they knew he had warrants. Like it just doesn't rise to that level. And I feel like I sort of covered that in my brief. So I would just rest on that in regards to that issue. I'm happy to answer more questions on issue 2. Okay, can I touch on issue 1?
Yes.
Okay, so just to touch on issue 1, even if you can't waive a structural error, because the issue is unpreserved, it's forfeited. That plain error standard from People versus Davis applies, where the third prong is, satisfied, but then the people can rebut the presumption that it seriously affected the fairness and integrity of the proceedings. In this case, the error did not seriously affect the fairness and integrity of the judicial proceedings because the jurors did get the instruction in their preliminary instructions, which was oral. I did submit Appendix B here, which shows that they had a copy of the fleeing and eluding instruction in their written instructions. And then when you look at all of the judge's instructions, I won't say them all because they're listed in my brief at page, I think 44 to 45, but basically the judge told them you have to instruct you have to take all of my instructions as the law you are to follow. At various times, I've given you instructions on the law. Take them all as you are to follow. So when you, and then the judge also instructed, every crime is made up of parts called every crime is made up of elements, and you have to find each element proven beyond a reasonable doubt. So when you look at the jury instructions taken all together, the jurors knew that they had to find the elements of fleeing and eluding proven beyond a reasonable doubt. And they at least had the elements before them at the beginning and in written form. So I would say that issue is not a cause for reversal. But other than that, I'm happy to answer any questions.
Thank you very much. Thank you.
Just briefly on prejudice, I think that's the heart of where we're at. This remark by the prosecutor where he states, quote, "That's what he does, basically. He's a criminal. He doesn't show up for court." That's just so striking. That just jumps off the page. This was a short trial. I think it was a 2-day trial. That doesn't have to be repeated. The prosecutor doesn't have to, in their closing remarks, quote that. The jury's going to remember that. And it's going to remember what they know about Mr. Nicole. They're trying to figure out whether he's guilty or not. What do we know about this guy? Oh, okay, he's been breaking and entering, domestic violence, aggravated assault. Those are all things that are going to be fresh in the jury's mind and prominent in the jury's mind when they go to deliberate. And so regarding prejudice, I have to say that this was a legitimate defense that was presented at trial. The car is driving through an intersection. The testimony was that it wasn't speeding. The officer's testimony is that he recognized defendant in the car. Whether defendant was driving or not wasn't particularly important. He just recognizes defendant. The car going through an intersection, that's going to happen relatively quickly. As to whether the officer saw the defendant driving or had that correct, that's a legitimate jury question. And this is what makes it even more of a legitimate defense. All right, as the car is going down the road, then it picks up speed and it evades the police and it goes around the barn. If defendant was driving, he didn't leave the scene. He stayed at the scene. I mean, he's charged with resisting arrest and everything. If he was the driver, if he was guilty, he could have taken off on foot. Now, I'm not arguing that he was innocent. What I'm arguing is that it was a legitimate defense that that was presented at trials to whether he was the driver or not.
Let me interrupt for a minute. I've already explained why I think, at least, and I think you've conceded might be the wrong word, acknowledged that the general reference to having outstanding warrants is relevant as to why the police officer made the stop. It's an element of the crime, fleeing and eluding. I think we all agree on that. The next question is whether the specific warrants were properly admitted. In looking through the lens of ineffective assistance of counsel, let me just look at it that way. It seems to me that defense counsel did exactly what defense counsel should do a motion to eliminate before trial, say, hey, I don't want these specific ones, these warrants to come in. Trial judge agrees, but then warns defense counsel if there's any challenge by any way, any argument or testimony, that there's an issue with why he was being stopped, then they come in. So, warning. Then at trial, I think reasonable minds can differ as to whether defense counsel opened the door or not, okay? If I conclude that defense counsel, if I conclude that the trial judge didn't abuse its discretion, which is how we review this on evidentiary issues, if I conclude that the trial judge did not abuse its discretion in concluding that the trial counsel opened the door, then they're admitted. Then I'm only left with those few improper prejudicial statements. Whether they're unfairly prejudicial is a question, I think. But I think that's another way, that's what I'm struggling through, at least with regard to ineffective assistance of counsel. There might not be 4 issues, there might be what's left at the end, at least in terms of ineffective assistance of counsel. Mm-hmm. Should defense counsel objected? I see no reasonable strategy why they didn't. But in terms of the admission of the warrants and the trial judge's decision and whether it abused its discretion in concluding, they didn't use the word open the door, but I think a lot of different judges would rule differently on whether this opened the door or not. And that's what abuse of discretion is. So how would you respond to that?
Well, and maybe this is a failure in my briefing because I think there's three ways to look at it. All three, I think, end up at the same place. Ineffective assistance, trial counsel opening the door, trial counsel not objecting, trial counsel not arguing. Wait a minute, I'm questioning the timing of when they learned of the warrant. Why would that open the door to these other matters? Prosecutorial misconduct, the remark by the prosecutor. But then there's judicial error.
So it sounds like, to his point, if defense counsel opened the door, and that winnows down the improper, unobjected conduct from the prosecutor, it's still ineffective assistance of counsel, B, for failing to object to the prosecutor's questioning, but A, for opening the door to the extent the attorney did that.
Right. I think frankly, all three, not sides, but all three court, prosecutor, trial counsel came together and made a series of mistakes here. And maybe my briefing could have broken.
No, I'm glad you were here.
Okay.
You answered the questions very
Okay.
well.
Okay, I appreciate, thank you.
Yeah, thank you both very much for being here. The matter is submitted. Turning now to item number 5, people of the state of Michigan. Oh, I'm sorry, these were consolidated cases. If I didn't say that, that was consolidated with 366489. Turning now to item number 6, which is people versus a yacht. That's file number 365780. I understand counsel is waived on that case. All right, that matter is submitted on the briefs. That turns to item number 7. However, in light of, we started early and I promised my benchmates that before this case, we would take a brief recess so you had our full attention. All right, so we're going to take about 5 minutes.
The Honorable Court of Appeals for the State of Michigan is now in session. Please be seated.
All right, calling the next case, Committee for Marshall, not the mega site versus City of Marshall et al. Item number 7369603. Before we begin, why don't we just confirm what hopefully we all know? How are we splitting up the time?
Yes, Your Honor. So I intend to spend the first 30 minutes addressing only the substantive merits of Committee of Marshall's appeal. I'll reserve 7 minutes for rebuttal. I understand appellees will then argue. I'll have my rebuttal time, and then we will switch to the cross appeal, in which case MEDC will argue. Committee will have its 15 minutes for response, and then MEDC, MSF will have rebuttal, so to choose.
Okay. And any rebuttal would come from the 15 minutes, just so we're clear.
Correct.
Okay, very good. Go right ahead.
Good morning. May it please the court. Robbie Doobie, Pro Hoc, on behalf of Appellant Committee for Marshall, not the mega site. A referendum delayed is a referendum denied. For over a year, the city has delayed and denied my client's right to a referendum. It has done this by flouting a century of precedent limiting a clerk's ministerial power to review a referendum petition for signatures and physical form requirements only. Instead, the clerk seized, and the circuit court approved, unlimited pre-clearance authority over the exercise of legislative power by the people. With this illegal power, the clerk denied a referendum on a rezoning ordinance the city had no authority to pass. The clerk wrongfully determined the ordinance could not be referred because it contained improperly inserted appropriations. These appropriations are unrelated to rezoning and were never properly noticed by the city. The clerk then rewrote the charter by fiat to impose an unconstitutional residency requirement on petition circulators. As this court's aware, appellant's brief has raised numerous issues. This court needs only agree with the committee on one to reverse. As a threshold matter, it was unconstitutional to reject appellant's signatures, and appellees have never once attempted to defend the constitutionality of that decision. From there, it effectively comes a cascade. At the top, can the clerk issue a certificate of insufficiency because she believes a successful referendum would be illegal? No. If the court overrides precedent to find the clerk can review for legal substance, it must go to the second level. Was the clerk actually right? Again, no. The appropriations cannot be passed by ordinance, and they fail the title, object, and single subject rules. Only if the court accepts the appropriations are valid must it reach the third level. Can the city override the Joint Planning Commission to rezone this land? And can it pre-publish notice of an ordinance that never references the appropriations contained within? For a final time, no. So appellees dedicate the majority of their briefing to procedural points. I intend to focus on the merits unless this court has a specific issue it'd like me to focus on. If not, I will first address the key issue of a clerk's limited ministerial power.
Right.
So the ruling that appellant wants here today is that the clerk should have issued a certificate of sufficiency with questions of legality reserved for after a successful referendum. This is right in line with Coalition for Detroit, for Safer Detroit, because to do otherwise would be to be giving an advisory opinion on the legality of a law. It would also, to do otherwise, grant the clerk a pre-clearance power. As we know, the legislature does not have to get approval from the clerk, from an executive agency or the court to pass legislation, nor does the city of Marshall. They pass legislation and then its legality is challenged. There is no precedent supporting the idea that that system would be flipped just because the people are suddenly deploying the power themselves. This court has been clear, sufficiency first, and then after a vote, you look at legality. And there's 100 years of precedent. We starting from Wilson v. Ganease in 1891, all the way up to reproductive freedom 2 years ago. It's a limited ministerial task to review a certificate of sufficiency. You look at the signatures and you look at the form. So what does form actually mean here? Form means the actual physical paper that the petition is printed on. If this court looks at appendix page 420, we had created a identifier of all the different Michigan law requirements that get put in that has to be on the physical form. Do you have the signatures in the right place? Do you have the right disclaimers? Have you checked all the boxes? That is what a clerk is supposed to look for. And we know this from the case appellees cite to support the opposite. They cite to Herp, the City of Lansing clerk, to say, well, there she looked at the legality and they rejected it. That's not true. In Herp, the clerk looked and said, hey, the Home Rule City Act requires you to put in a notification of who is circulating the ballot committee name. And they hadn't done that. So the clerk said, this is insufficient. That is correct application of the ministerial power of looking at form. Do you have the actual the information on the document? So then that leads us directly to Coalition for Safer Detroit, which is right on the money here. There, the court said, we agree with plaintiff that it was not within the scope of the city clerk to assess the substance of the petition or determine whether, if passed, it would conflict with state law. Reproductive freedom for all, the Justice Beth Kelly decision has the exact same ruling for the State Board of Canvassers. Then it goes on and says it was outside defendant, the clerk's authority to consider the substance and effect of the initiative. So Coalition is repeatedly clear here. The clerk is not a judicial officer. She does not have the judicial power to look at a proposed legislative act and say, this will be illegal if passed. What she does is she says, the form here is all correct or it's not. But that's not what this clerk did here. She took it upon herself to say this would be illegal. Further, the court in Coalition for Detroit said the trial court erred when it addressed whether this would be legal or not. So even to get to the trial court level, for it to say, I'm going to deny mandamus because it would be substantively illegal, the Coalition court said, you can't do that. You have to wait for it to pass because we don't give advisory opinions. So the circuit court, despite Coalition for Detroit, tries to distinguish it, right? It says that the Detroit charter is limited to canvassing the petition, so the Marshall charter is limited just to sufficiency. So that implies that the clerk can look for other things. Well, there's two issues with that. One, statutes don't give implied grants of authority to executive agencies. They are explicit when they grant that. But even more importantly, that's not what the Marshall charter says, nor is it what the Detroit charter says. The Detroit charter says you canvass the petition for sufficiency. The Marshall charter says you review for sufficiency. So the Detroit charter and Marshall charter say the exact same thing. You look at sufficiency, sufficiency goes to form. So Coalition, again, is right on the money. So then it says it's bound by MGM. It says MGM stands for the proposition that the clerk does have this power and you can't refer this. There's a couple issues with that too. One, MGM never said that. It's an 8-paragraph opinion dedicated majority to mootness. It doesn't say the clerk has that power. It's never been cited to say the clerk has that power. But also, there's a key difference in the Detroit charter and the Marshall charter. The Detroit charter says your budget can be passed by resolution or ordinance. The Marshall charter says you have to pass by resolution. That is a crucial difference that gets to the second level.
Before we move too far from that, for MGM, acknowledging that it's not directly addressing whether a clerk exceeds their ministerial review when they certify a petition on the ground that a referendum also includes appropriate or addresses something that also includes appropriation. I guess, what's your response to, you're right about that, but the main takeaway from MGM is that it plainly held that the trial court correctly denied defendant's request for a writ of mandamus to compel the city clerk to certify the petition. I mean, that's the top line of MGM, or that's the bottom line of MGM. What's your response to that?
Two responses. One is Coalition for Safer Detroit, which comes after MGM, clearly stands for the propositions that the court will now say certify for sufficiency first and then come back to us on legality, right? That's what Coalition says, and that comes after MGM. So for Coalition to have any validity, MGM cannot be read to say if a clerk weighs on legal substance, you're done. Coalition has to be read to say, okay, that may be ultimately true. The legality may ultimately be suspect, but right now we are ruling only on a certificate of sufficiency. So that's one. Two, the Supreme Court did no analysis of the Detroit Charter and how it applied to the appropriations. The Detroit Charter there, the appropriations were validly inserted. Here they are not only for the failure to follow the charter procedures, but also for the title object violations. And so before I move on to that level two, there is an issue that I want to address, whether mandamus is the proper remedy, right? The city has now argued, raised originally on a reply brief after oral argument, that an administrative appeal is actually the proper remedy. Well, a Michigan court has never once held that. There's not a single Michigan opinion that ever says the remedy to compel an election official to do her election duty is administrative appeal. It is repeatedly clear that it is mandamus. So what the city says is, well, but the city council, you appeal to the city council, and then you need to appeal upward. And how they got there is they used brackets to change the word of their charter in their brief to you. They said the city council reviews the petition for sufficiency. That is not true. The city council reviews the certificate of insufficiency. And that is crucial because the certificate of insufficiency is a ministerial task to create and a ministerial task to review. There's no discretion as to whether you met the form or not. There's no discretion as to whether you met the signatures. So just because it comes up to the city council doesn't mean the city council is suddenly vested with discretionary power to go look for whatever reason they may want to uphold or to overturn the certificate of insufficiency. They are still operating in a ministerial role. But even if that wasn't true, the charter doesn't say appeal, it says review. And we've cited in our brief Black's Law Dictionary the important difference between review and administrative review. But even if that wasn't true, nothing about this procedure was quasi-judicial. Of course, the record's not before this court because the circuit court went on its own on a C8 motion to rule that it was quasi-judicial when that's supposed to be an evidentiary determination. But here, under Michigan law, to be quasi-judicial and thus subject to administrative appeal, you have to have a right to cross-examine, a right to submit evidence, a right to subpoena, a right to argue, a right to counsel. This was a 5-minute city council hearing. They gavelled it open. They said, here's our certificate of insufficiency. Here's the committee's letter. We uphold. That's not quasi-judicial. And no administrative appeal could spawn from that, even if the century of precedent saying it's ministerial is somehow no longer valid. So mandamus is the proper remedy. Mandamus should issue here to order the clerk to issue a certificate of sufficiency for questions of legality to wait until only after a successful referendum petition. That still brings us to also the other threshold issue this court has to agree on for mandamus to issue, which is the signatures. Which is very
Council, you're welcome to address that. At some point, I would like you to address the appropriations by ordinance, though.
I'll go ahead and go to that then. We feel confident that the constitutionality of the signature issue is clear. You cannot put a residency requirement in. They've never once attempted to defend the constitutionality or overcome strict scrutiny. It's very clear that this residency requirement is simply unconstitutional and doesn't meet the form of the charter itself. So I want to go to first, did they pass these appropriations correctly, right? Nowhere in the briefing is there any example anywhere of the city of Marshall appropriating via ordinance. There just isn't any. But here, for the first time, we have ordinances put into a rezoning ordinance, or excuse me, appropriations put into a rezoning ordinance. And the question here is, how do you actually pass an appropriation in the city of Marshall? Now, appellees say there's a general power to legislate by ordinance or resolution, and that is true. But the city has the power to then limit which type of powers it can deploy, right? Just because there's general powers granted doesn't mean a city can't choose to limit it from there. That's exactly what they've done. If you look at Marshall Charter Article 9.05, the city council shall, by resolution, adopt all budgets for the next year, and in such resolution, make an appropriation of money needed for municipal purposes. So you start with the budget as a resolution, not an ordinance. Then in 9.06, they say after the budget has been adopted, no money shall be drawn from the treasury, nor any obligation for the expenditure be incurred, except for pursuant to budget appropriation. And any transfer must be done pursuant to the budgetary process. So any appropriation out of that budget or change within the budget is governed by the budgetary process. What is the budgetary process? Resolution. The city chose to limit itself that way. That's not something appellants put on them. They chose to limit their power. So they can only appropriate via resolution. They could go change their charter tomorrow to change that, but as it stands at the time of the referendum and the time of the ordinance, it is resolution only. But they pass the appropriations in an ordinance. They can't do that. They are violating their own charter to do that. So then what they respond is say, well, that makes 5.01 superfluous because it says you can't refer an ordinance relating to appropriations. And there's two problems with that. One is 9.08 specifically says you can, by resolution or ordinance, pledge the full faith and credit, bond, or loan of the city. So very clearly, right then and there in 9.08, there is an appropriating mechanism that is done by ordinance or resolution. 5.01 directly implicates that. If the city chooses to do a 9.08 appropriation via ordinance, it's not referable, plain and simple. But even if that weren't true, just because a provision in a statute or constitution lacks for application does not make it superfluous. Superfluous means it is quite literally meaningless to be in there because it is overridden by something else. That is what happens under their construction for 908. If you read that, actually, when it says resolution, you could always just do ordinance. Well, then there's no reason to ever say ordinance or resolution because you can always do it by ordinance, right? Why would you ever distinguish, hey, we can do it by this method or this method that we can always do, but we're just going to only say it here in this one provision? That doesn't make sense, right? So 9.08 is rendered superfluous if ordinance is always implied into the power. But 5.01 is not rendered superfluous even if the city has chosen to take away ordinance appropriation by ordinance, because all that means is it lacks for want of application. That is not render it superfluous. Finally, to accept the city's proposition of how these have to be appropriated means taking away the word shall and replacing it with may. You may pass by resolution, but also you can just do it by ordinance, and that's what we did here. Well, then that means shall in every other part of the charter falls apart, and we've laid out in our brief numerous provisions as to how that can't work. So the shall has to be mandatory. Resolutions are mandatory. This is put into the ordinance, and that's crucial because the ordinance is severable, right? If some part of it is found to be invalid, you can sever it. So appellant's entire argument here is those appropriations are invalidly in the ordinance. You need to sever them from the ordinance. Now we have a referable, ultimately legal referendum. Now, the final thing to remember here with that one specific issue is Charter Township and Meridian. All ambiguities are supposed to be construed in favor of referendum rights. You are supposed to read charters and referendum enabling provisions in the most referendum friendly light you can. That is appellant's reading that we've presented to this court. So then turning to the title object violations, if you read appellee's brief, you would think the ordinance is titled an ordinance to develop an industrial project. That is not the title of the ordinance. The title of the ordinance is an ordinance to amend the zoning map of City of Marshall so as to change zoning of a parcel of real property, parcel number, from township zoning to industrial and manufacturing. That difference is crucial because the title doesn't mention appropriations, doesn't mention a budget amendment, doesn't mention an industrial project anywhere. And from the actual title, you don't know that there's going to be site plans or building inspections. The title tells you nothing about an industrial project. It tells you about rezoning, and that's crucial for a couple reasons. One, we've put in the Laidlaw affidavit where there's not been an example of a rezoning ordinance containing appropriations, but also there's not an example of any ordinance besides conditional rezoning that can be for a specific project. You can't rezone for a specific project, period. That's the MEZEA is clear. Only if it's conditional rezoning. So to say we're rezoning for this project and all of this is to develop this project is categorically untrue. Further, you can't appropriate in a zoning ordinance except for a purchase of development rights, MCL 125.35072. That's the only kind of appropriation you can have. So if you're an individual citizen reading this ordinance and you say, oh, we're going to rezone, you would not think that there was going to be any appropriations in there. Right? And then they say, well, the purpose of the statute is to develop the industrial project. That's not true. The purpose of developing an industrial project is specifically in the appropriation section. But we can't have the title object and single subject rule be conditioned on so long as I throw in a different provision and give it its own purpose within the statute, suddenly the statute or ordinance takes on that whole provision. That would just nullify the rule. Right? And then we come to what are these actual appropriations? They're not zoning related. They are construction regulations, and that's really important. A site plan is not an act of zoning, and it is not generated by zoning. You can zone and the land could stay in the new zoning forever with nothing ever happening to it. Happens quite a lot, actually. Only once you go to move to build something, do you need a site plan, and then do you need a building inspection? So to say we're rezoning and therefore we need a site plan and building inspection is not true. You rezone, and then as a separate, distinct act, you enter into the construction phase. That is what Michigan law provides. Construction regulations does not include a zoning ordinance or rule issued pursuant to a zoning ordinance.
So council, what's the smallest change they would have had to make to the title here in order to, in your theory, comply with the title object rule?
An ordinance to facilitate the development of industrial property. That's all they have to say. They say that's the whole purpose of the statute. That's a very easy language to put in, but when they specifically chose rezoning, that is a specific legislative act taken under specifically enumerated powers that is specifically excluded from construction regulations. That is the fatal flaw here. And this gets to kind of the disagreement parties have over the standard, whether it's necessarily connected under man, as we assert, being persuasive dicta versus naturally connected. Ultimately, it really doesn't matter because they're not naturally connected and they're not necessarily connected. And we know that because the city's own official, Zuzga, said this is not for an end user in mind. So it can't be for an industrial project. So by the city's own admission. And if we look at the material the city had for when it was approving the rezoning, the appropriations aren't in there. Finally, there's just this interesting question we have of where are the appropriations? They're not in the budget and they're not in the zoning map. And that makes sense that they're not in the zoning map because you can't amend a zoning map and add appropriations in. But neither can you amend your budget by rezoning. You have to take those discrete acts. But if you actually look at the Marshall records themselves, they appear to be ghost appropriations. They're simply not in there. And so there's a very strange question of whether this was even a real appropriation at all, for that matter. So on those second level, even if you find the clerk has that power, the appropriations simply fail. They have to be severed, and then the appropriation becomes referable. So the clerk was wrong. I want to talk briefly about the 4.02 notice and the Joint Planning Commission. Does this court have a preference of which one I address first?
No.
Okay. So for the notice, we know a city has to comply with its charter. We've provided that it should be strict compliance. They've argued substantial compliance. Again, the standard does not matter for the facts on the ground here because of what actually happened. So here in the timeline, MEDA applies for rezoning. It goes to the Joint Planning Commission. Then while the Joint Planning Commission is considering, the clerk publishes notice of an ordinance. The ordinance doesn't exist, but she publishes it. Then the city introduces it. And then on April 22nd, there's a summary of actions. And then for the first time on May 1st, we find out there's appropriations in there. If this court looks at Appendix 409, that is the notice. If you read that notice, the appropriations aren't mentioned anywhere in that notice at all, whatsoever. If you read the summary of action on Appendix 537, they separated, they said, here's what the council did on the 17th. We already approved the contract for site plan review. They don't say anything about building inspections. And we set a public hearing to consider zoning designation of the industrial process. So even in the notice, which we feel very strongly, you can't pre-publish a notice. That creates some sort of balancing test of harm that isn't found in the notice. But let's even assume that you could publish a notice of an ordinance that doesn't exist. This notice fails. The appropriations are nowhere in there. So if you are a citizen who's interested in appropriations or taxing, you'd have no idea that this is a meeting that you should show up to. And this is another area the circuit court erred on. They said, well, appellants did show up. Excuse me, appellant and petitioners did show up. Well, petitioner James Slide Jr. did not. And he would have if we had been given the chance to present evidence. And I know that court can't quite consider this, but it's to demonstrate the point. He would have shown up if he had known that there was appropriations in there. All right, so the notice fails. And then quickly, with the time I have remaining on the Act 425 issue, here, the argument is simply, what does it mean? What does shall mean? What does control mean? What does procedures mean? The Act 425 agreement states that the Joint Planning Commission shall control and land use shall be subject to the Joint Planning Commission. Control and shall means, of course, you have to go to the Joint Planning Commission, but then control, as we assert, means that they actually have final say. If another body can come and override whatever decision they have, they don't actually control rezoning. Now the city says, but you adopted our policies, and our policy says that our planning commission is advisory. That may be true, but that procedural step cannot be overridden by the contractual agreement that the JPC shall control. Because if it does, the Act 425 transfer has now become an illegal annexation. Because now the Township of Marshall has no control over the zoning of its property, right, that's been transferred. I believe there's cases we cite in our brief, but regardless, the point remains, it's really a question of statutory interpretation. What does shall control mean? What does subject to mean? Does that override procedures? We argue that it does. And if it doesn't, then it becomes a Act 425 issue, a annexation issue. So with that, that would by ruling on appellant on either prongs 1 or 2, that entitles them to the preliminary injunction they should have received below, as the martial charter mandates suspension of the ordinance once a certificate of insufficiency has been issued. So with that, I will reserve the remaining of my time for rebuttal unless this court has any additional questions.
I don't see any. Thank you.
Thank you.
Just checking the time to make sure I can still say good morning, Your Honors, and may it please the court. Zach Larson with Clark Hill on behalf of the City of Marshall and the Marshall City Clerk, Michelle Eubank. And to Judge Cameron's point, per our letter, we have agreed that we're splitting our time equally between myself and Mr. Zdarsky on behalf of MEDA. Your Honors, a mandamus plaintiff does not have a clear legal right to a referendum on a municipal ordinance containing appropriations when a city's charter plainly excludes the right to referendum on any ordinance relating to the appropriation of money. That was the holding in MGM Grand involving a nearly identical City of Detroit charter provision, and the trial court correctly acknowledged that MGM Grand controls here. Thus, the committee appellant's principal claim for mandamus fails for that reason alone, though not solely for that reason. Beyond appellant's unsupportable mandamus claims, the trial court also correctly determined that the committee's other scattershot allegations claiming the city has violated its charter were simply unfounded. And I can briefly address each of those claims. If we start first with the mandamus claim, I think it's important to note that the committee has the burden of establishing all 4 elements of mandamus. And although they've tried very hard to make its mandamus claim solely about whether or not the clerk exceeded the boundaries of her review, that focus is both erroneous and insufficient to prove that it prevails on appeal. It's insufficient because with respect to, because the argument really, it sidesteps the committee's affirmative duty on the clear legal right prong here, and it didn't have such a right. If you look at section 501B, the city charter plainly states that the referendum power shall not extend to the annual operating budget, any emergency ordinance, or to any ordinance relating to the appropriation of money. The case law is clear that cities can provide for referendum and that they have the ability to determine the scope of that referendum right. And so these restrictions restrict ultimately the ability to proceed on a referendum. And that section is broad.
Fair to say, if we agree with the lens that you're looking at this, we could almost silo the mandamus issue to say, even if there's problems with the ordinance and how the ordinance was passed, that doesn't then translate into a clear legal duty that would entitle plaintiffs to mandamus.
Absolutely, Your Honor.
Even if the ordinance is wrong, that doesn't, just based on what's in the charter and what's in the referendum, clerk can look and say, oh, well, this part of my ministerial function, my common sense, this can't be a referendum.
Absolutely, Your Honor. They can say that simply looking at it and seeing the fact that there's dollar signs there, there's money being appropriated, the clerk can conclude that this falls outside of the scope of the power that she has to put this on the ballot. And I think that the case Citizens Protecting Michigan's Constitution goes to that question of clear legal duty and clear legal right when you have this threshold procedural question, which is exactly what this is, a threshold procedural question of whether or not it can go on the ballot. And that threshold procedural question resolves against the ability to have an initiative or a referendum. Then, ultimately the answer is there is no clear legal right, there is no clear legal duty. So this case is very different from, for instance, the focus of the committee on the Coalition for Safer Detroit, because this isn't a question of the substantive merits of this law. It's not the question of the clerk looking at the ordinance and saying, well, if this passed, it might conflict with some state law or some federal law, conducting a preemption analysis or otherwise judging the substance of what's being passed. Instead, it is a threshold procedural question of whether or not it's even referable in the first place. And here, when you have, section 501B saying any ordinance relating to the appropriation of money cannot be referred, there's no broader words than any. The charter couldn't use broader words. Relating to also is extraordinarily broad. It's not even just those that contain an appropriation. It's those that relate to an appropriation. And then finally, the fact that section 501B separately says the referendum power shall not extend to the annual operating budget clearly contemplates that there are ordinances relating to the appropriation of money that are not the budget, right? It's sort of been, addressed that, well, that's the only thing. The committee is making the argument, you have to cabin that over here. You can only appropriate through, the budget and related resolutions. Well, if that were true, then it really negates 501B separately calling out the budget and any ordinance relating to the appropriation of money. And so here, where you have, two appropriations, one for $40,000 for site plan review services, another for $250,000 for building inspection services. This is clearly an ordinance that relates to the appropriation of money, and it's non-referable as a procedural matter. And MGM Grand is directly on point. In fact, the only real difference between MGM Grand and this case is the fact that the charter provision says that Detroit's the referendum power in Detroit did not extend to the budget or any ordinance for the appropriation of money. So it was, if anything, a little bit narrower in terms of, the carve out for appropriations. So there's no wiggle room. MGM Grand controls. And if you decide that, you really don't have to address even the other prongs of mandamus because that is dispositive. But briefly, touching on the other prongs on mandamus, I'll just say, I've already mentioned the Coalition for Safer Detroit. But on clear legal duty, another important case to look to is the Citizens Lobby of Port Huron case that says specifically a city council may, quote, determine upon the advice of corporate counsel that the subject matter of the petition is not properly referable to the electorate. There, the question was, is an administrative, is the ordinance administrative in nature or legislative in nature? And this court said it was permissible for the city council to make that determination. Here, the trial court pointed out that you have not just the clerk acting, but you have the city council upon review putting its blessing on this. And therefore, what's being challenged in mandamus is not just the clerk's action, but the city council's action. And so when you then apply Citizens Lobby of Port Huron with that framework in mind, it's clear that the city council has the ability to make that determination. Moving briefly to the question of whether or not it's ministerial, it's our view that because city council is reviewing this, their action is not ministerial. The case law is clear that city council has various administrative functions. Those include quasi-judicial functions. It's not too important to get into the question of quasi-judicial. We don't take the restrictive view that the committee has put forth here this morning about what's quasi-judicial. Quasi-judicial really includes any right to hearing. It doesn't necessarily demand an evidentiary function. Comments submitted to council that can be reviewed is, evidentiary in a certain sense, and this court has indicated that in case law. But the point is, when it comes to ministerial, the question is whether the law leaves nothing to the exercise of discretion or judgment. And when city council is reviewing that, they certainly have discretion and judgment. It is not a purely ministerial duty. The fourth element is whether or not they have other relief available. And what that goes to is the fact that mandamus is an extraordinary remedy. Mandamus doesn't step in just in any given circumstance. You have to be left with nothing else to go in front of a court with for mandamus to be available. Case law is clear. It's not a permissible remedy when there's an appeal as of right. The MCOA versus Flint Charter Township case addressed that. The court rules, MCR 3.302D2 says exactly the same thing. If an appeal is available, that method of review must be used. Well, here, the city charter under section 504C very specifically says that after you go to the city council, a final determination by the council as to the sufficiency of the petition shall be subject to review by a court of competent jurisdiction. Now, whether you want to look at that as an appeal or as something else, it certainly precludes mandamus. Why? Because you have an express cause of action, and mandamus being an extraordinary remedy in equity that steps in when there is no express cause of action, there is no ability to bring mandamus when you specifically have a law that provides for your cause of action. The question of appropriation by ordinance, I've already touched on this briefly. you know, whether it can only be done via resolution or via ordinance, it's very easy to resolve just by the text of 5.01B itself. You know, it provides explicitly for ordinances relating to the appropriation of money that's distinct from the budget itself. The other point to make there is that 4.01 is clear in saying that the powers of the city council allow them to choose between resolution or ordinance unless there's some sort of an explicit restriction on that. There is no explicit restriction to the point of how you construe these provisions. Charter section 1.05 says that you are to construe the powers granted to the city council liberally in favor of the city council. That's in the charter itself.
Council, can we just back up for one moment? So,
Yep.
in reference to 501 or 501 sub B, what do you make of the argument, or I guess one, what do you make of the argument that, well, really what this is contemplating is you've got a budget that provides kind of your bucket or your universe of appropriations for that year. And then 501B allows you to decide how to move money around within that. If you decide later on, look, we've got this surplus, we didn't spend as much as we expected, so we're going to take this from, bucket A and move it into bucket B. I guess that's the first question. What do you make of the argument that really that's what that section is saying? You can do that by ordinance, moving it around. And second, to the extent the city wants to do that, if it wants to draw, say, we're going to take the money that's at issue in this case for the site inspection and the other item, we're going to take it from something else that we've earmarked it for. What is the mechanism for them to do that?
So Judge Hood, in terms of the first question, yes, they can move things around. You know, what 9.05 and what 9.06 is looking at is the annual budget, right? So it is setting the numbers up front that where you're projecting, this is where we're going to spend our money. And so here's our budget, we've adopted it, and then we appropriate for that. But then throughout the course of the year, you can make adjustments to individual, suit individual needs. If that weren't the case, then certainly it would be a problem for city government, if they have to rely exclusively on what's been set out at the annual budget.
And that would be by ordinance?
Well, that can be. So in terms of the general operating budget, that is by resolution at the beginning of the year. Though I'll say that an important point to make in 9.05 is that the shall by resolution refers to the adoption of all budgets for the next year. There is a question as to whether or not it really applies. The by resolution applies to then the trailing, is a leading modifier that applies to the trailing language at the end of 9.05 that says, and shall make an appropriation of the money for municipal purposes. I wouldn't concede that, by resolution in this context modifies the appropriation. Instead, it's really just to the budget itself. And if you can repeat your second question, I think I may have forgotten.
The city wants to do that when they've got their properly passed budget and they want to move money from one bucket that was already identified to something else. They're not trying to get more money than what they've already budgeted for, but within our universe of funds that we have, we want to move it from bucket A to site inspection. What's the mechanism they use?
They have the flexibility to either do that through a resolution or through ordinance, right?
So what I'm getting at is, what's your response to the argument that, section 501 sub B, that's what it's talking about. That once you've got your total funds, budgeted for, you can then use an ordinance to move it from A to site inspection.
Yeah. I think we wouldn't dispute that, but I think we would say that is what happened here, right? And that they're not coming up with new funds. What they are doing is they're ultimately making an appropriation out of what has been allocated previously under the annual budget, right? So, and specifically in this case, and this kind of bleeds into the title object question, which I can kind of move on to, but specifically what in this case, what you're doing there is, they're looking at a project that's going to be a massive industrial development, and the rezoning is facilitating the massive industrial development, whether it's this project or it's a different project. And then when they're making these appropriations, they're acknowledging the fact that this is a small city, and if they're going to facilitate a large industrial development, they will need additional staff. They will need, additional resources to conduct the inspections that would go along with such a project. So it doesn't have to be specific to, the Ford Blue Oval plant. It can be generically to the point that we've rezoned this large property. We are going to try to, facilitate a development on this property, and these appropriations will help facilitate that. And on the title object point, Judge Hood, I believe you asked a question about, what needed to be in the title. And the answer there is, first of all, when you're considering the purpose for title object, from the title object standpoint, you don't look just to the title, right? So title object has two different, arguments related to it. It has the single object or multiple object argument, and then it has the title object point in terms of the correlation between the title and the title body point in terms of the correlation between the title and the text of the ordinance. But when you're discerning the general purpose of an ordinance for determining whether or not there's germaneness between the title and the body, or germaneness between multiple objects, what you're looking at is the entirety of it, not just its title. You look at the title, but you will also look at the fact that, you have an ordinance that at section 1 declares the purpose of the ordinance and says, this is what we're doing. This, our purpose is to generally promote the, public health, safety, and general welfare of the residents by regulating land use for safe and efficient use of lands. You look at the fact that they're, what is it accomplishing? Well, it's accomplishing through section 2 a rezoning. It's accomplishing through section 3 related costs that would implement that. And so, that helps you determine the general purpose. Now,
you'd mentioned you were splitting your time.
Yes.
And you're at 15 minutes right now. You just let you know.
I will make one final point, and I'll hand the torch off to Mr. Zdarsky, and that is just to finish my thought on title object. This court can look just to one case to resolve the title object issue here, and that is Kuhn versus Department of Treasury, because there you have the legislature passing the Income Tax Act and appropriating $3 million to the Michigan Department of Treasury in order to facilitate the implementation of that. That's exactly the kind of thing that's happening here. An appropriation to facilitate the implementation of the legislation that's being passed. And there's therefore no title object problem. And with that, I'll hand it over. Thank you.
Good afternoon, Your Honors. My clock just turned to noon, so I can say good afternoon. Christopher Zdarsky from Bodmin on behalf of Marshall Area Economic Development Alliance, an intervener and the property owner of the subject property at issue here. I want to start by, there's been a lot of discussion about the appropriation being contained as part of the ordinance, and if the appellant's attack here that, well, even if there is the appropriation is contained and the charter says what it says about those types of ordinances not being referable, I can backdoor it here because I can assert that the appropriation is invalid and illegal. But before we get to that point, I think we need to take, and we've been living with this case for a year and taking 3 big steps back here. And the procedural points that appellant's counsel stated he wasn't going to touch is really the elephant in the room here. And that is, does the appellant, the lone appellant, the committee have standing to bring the claim with respect to any of its counts 1 through 5, 1 being the writ of mandamus, 2 through 5 being alternative claims for declaratory judgment? The answer is, and I'll take it, give a headline here, and then I'll loop back to each of these points. But the committee does not have standing on any of these claims with respect to the mandamus claim for the reasons we've talked about. There's an appropriation contained within the ordinance under 5. Therefore, there is no clear legal right to a referendum, and therefore you do not have standing to bring that claim. You cannot satisfy that element, and that's foundational and fundamental. Number 2. Alternatively, we're going to backdoor the claims here by saying, I recognize that there is this appropriation here. I need to deal with this. And therefore I need to assert that I can sever the appropriation. Well, how do we sever an appropriation? And how does the committee sever an appropriation? The committee, I remind the panel, was formed by virtue of the charter. They're a creature of the charter that says when an ordinance is passed, if residents don't like it, they can form a committee, and they can form the committee pursuant to 5.02. And that any 5 qualified electors of the city may commence initiative or referendum proceedings by filing an affidavit with the city clerk stating they will constitute the petitioners committee. They exist ex post facto, after the fact that the alleged harm here with respect to the illegality of the passage of this ordinance exists. This claim, to the extent it exists at all, it belongs to the residents, the committee members themselves, not the committee. And they are and the committee here does not have standing to take up the baton of those residents. And we'll talk about that a little bit with respect to the committee's argument in its reply brief, when it recognized that it only filed a claim of appeal on behalf of the committee and not the residents, that it was in fact taking the position that it did take up the baton by raising this associational standing argument. The individual petitioners here did not appeal, and that's critical. It's critical because they did bring claims in the circuit court. They lost. A final judgment was entered against them on all of their claims, and they did not appeal. And therefore, it's for that reason here that there cannot be any associational standing. The committee is not eligible to stand in the petitioner's shoes, right? As we talked about, the committee is a creature of the charter. When you look at associational standing, and the cases cited by the committee here, they're talking about you're able to have associational standing when an organization or association is created for a specific purpose, or that it's related, the action being brought on behalf of the city's residents here are related to the organization's core mission. What is the core mission of the committee? What is the specific purpose for which the committee was created? One purpose, and it's the purpose is to initiate referendum proceedings, for lack of a better word, in terms of circulating petitions, trying to get on the ballot in terms of the referendum, right? What we don't have here is they're not a nonprofit corporation. They're not incorporated. There's not a general position here that we are a nonprofit that is interested in the preservation of agricultural land and not having heavy industrial development here in the city of Marshall. And for that reason here, they cannot stand, there's no unity of purpose, and therefore there's no associational standing. Even if they were capable of standing in the shoes, for the reasons I just mentioned in terms of the city's residents bringing the action in the first place and having a final judgment entered against them, they're stopped because of the fact that they are now this committee is now claiming to stand in the shoes of litigants who lost, had a final judgment entered against them, and did not appeal. And so for that reason, to the extent they even could have standing, if the city's residents had not brought the claims, the reality is the city's residents did bring those claims, and they clearly brought those claims because, right, from our perspective, and it's clear from the appellant's brief in terms of them believing that and referencing appellants as being plural and all of the city's residents, it's clear from their petition, amended petition, that it was really I'm the committee, I want a referendum. If you're not going to give me a referendum, I have city residents who want to challenge and claim to have standing to invalidate that ordinance. And so because of the fact that they brought these claims together, the city's residents lost and chose not to appeal. There's an issue in terms of estoppel and the committee not being able to take up that baton and move the ball forward. Even assuming that they're not stopped, There's no unity of interest here. The committee is not the real party of interest for the reasons of it's not their core mission. It's not a specific purpose. The committee's purpose is clear. They're a creature of the charter. The charter says you can create a committee to seek a referendum. And really the last hurdle is, even if you assume that they can clear all those prior hurdles, the associational standing really relies upon the court looking but beyond the committee itself and looking at each of its members. And do each of those members have standing? No. Those members, right? Let's look at the amended petition and what the city's residents alleged was their injury here. Paragraph 14, it's in Beta Appendix 94. While touted as a development for the city, many city electors view the Ford Blue Oval Battery Park, Michigan plant to be a dangerous environmental risk to the Kalamazoo River and the agricultural lands around the city. In other words, there is no particular injury that any of these residents are suffering or being harmed by virtue of this ordinance being passed. They just want to complain about the fact that there are generalized concerns about the environment, and the case law cited in our brief makes very clear that that is not sufficient. The petitioners here and the appellant needs to articulate something above and beyond that in terms of a harm that is suffered unique to them beyond the general citizenry here. And they have leaned right into it by saying, we don't need to. We filed an original petition, made no effort to articulate a harm that is unique or separate and distinct from the general population. And then when they filed their amended petition, they doubled down and made the same arguments. And so for those reasons, there's no associational standing here. As a result of that, you need to look back to, okay, so you have the committee who is bringing the claim for mandamus. I'm not going to take a gratuitous lap around the track regarding the mandamus claim. Judge Hood, you asked about the appropriation, right? And MGM and counsel for the city did a nice job in terms of outlining. It really starts and stops with there is an ordinance. It contains an appropriation. The charter prohibits such ordinances from being referred, and that's the end of the analysis as far as that claim. And the distinction between that type of analysis and the MGM analysis and the case cited by appellants and relied on appellants in terms of the Coalition for a Safer Detroit is the fact that the clerk was not looking at this ordinance and determining whether or not passage would be lawful or what its impact would be. Instead, it simply looked at the charter's plain language about what types of ordinances are subject to a referendum.
Not to slice it too thin, but the difference being if the clerk looked at it and said, well, this specific appropriation in this ordinance is unlawful, and therefore, we can't include it, as opposed to saying there's just an appropriation in there at all. Doesn't matter if it was properly passed. I don't even have to think about that. There is an appropriation there, so we can't touch it.
Correct. And that's where and so the residents acknowledge that. And so then they pivot to, okay, well, let's sever the appropriation. And I'm entitled to a referendum once I am able to sever. Well, in order to get there, you need to have standing. Somebody needs to have standing in order to challenge the invalidity in the passage of this ordinance. And again, for those reasons I just discussed, in terms of there being no particularized injury, in terms of how this came to be enacted, that there's no ability to challenge those claims. The reality is this is a political question, and it should be handled politically. And it's not something where they are claiming that they have a right to a referendum. It was the first thing that they've said in their briefs. It's the first thing that counsel told you when he stepped up here today. The problem that we're facing here is the appellant's failure to recognize they just don't have a right to a referendum. And so kind of switching gears a little bit, I want to, I'll start from the back end and work my way forward in terms of addressing some of the other claims.
Just so we're clear, I don't think you have a lot of time to switch gears on, but go ahead.
Sure. With respect to notice, the notice was complied with the charter. And to the extent that even if the court were to find that it didn't comply, substantial compliance is what is required here, and that's the standard. It's something that we fought about in the circuit court. Judge Marietti agreed that substantial compliance is the standard here. The cases that appellant has relied upon in terms of strict compliance deals with statute of limitations in terms of providing an individual providing notice to a municipality with respect to notice pertaining to, I'm intending to bring a claim against you for damages. In those types of circumstances, it's treated as though it's a statute of limitations. You must provide notice within a certain amount of time. And in those cases, when there's not strict compliance, courts have found you're out of luck. With respect to zoning ordinances and municipal actions, substantial compliance is the road we go. With respect to the pre-publishing of the notice here, this is a weekly publication. This is not a situation where we need to go down a parade of horribles and ask ourselves, what happens here when we pre-publish a year in advance? Because that's not our case. That's not our reality. The reality is it was published 2 days before it was introduced. That weekly publication was still in circulation the morning after that May 1st hearing where it was introduced. And so at that point, publication has occurred following introduction, and therefore we've complied with section 4.02. With respect to the Act 425 agreement, very quickly.
You need to wrap it up.
Sure. It's very clear. You look at the zoning ordinance. There is having the JPC, the Joint Planning Commission. All it did is it supplants the Planning Commission. The Act 425 agreement references the zoning ordinance. It references that it's going to be subject to the city's zoning. And therefore, in that case, you look at the zoning ordinance and you see the city council is still at the top of the food chain and entitled to make the decisions like it did in this case in terms of enacting the ordinance, despite the recommendation from the Joint Planning Commission that it not. So with that, thank you, Your Honors.
Go ahead.
Thank you, Your Honor. A couple points here. One, Judge Hood, you'd asked if you want to transfer within the budget, can't you do that by ordinance, right? If you're trying to move it around after you've passed it. No. Article 9.06 says if you want to transfer, you do it by the budgetary process. The budgetary process is a resolution. So no, you cannot transfer by ordinance. The city chose to limit itself. And 5.01 does not supply that power. 5.01 is in the referendum provision. Article 9 is the budgetary provision that lays out how the city will pass its budget. So you cannot go to another provision that references budgetary referendums and say, oh, that therefore is a grant of authority to the budgetary process. That's in statutory construction. You have to look at the section that the enabling power comes from. That is Article 9. Article 9 says budget by resolution, transfers after the budget has been passed by resolution. Additionally, brother counsel for the city said that the site plan and building instructions facilitates rezoning. That's not true. Rezoning is a discrete act. Site plans and building inspections do not facilitate that. Site plans and building inspections facilitate construction. They are entirely separate. You don't have to have any site plans or building inspections to ever have rezoning. In fact, except for the example of the city, no municipality has ever done that, right? So that is not, they do not facilitate it in any way. That is just clearly erroneous. And then brother counsel for the city effectively said, well, the title doesn't actually matter. Just go look at the purpose, and the purpose here can tell you what you need. The title does matter. If you're saying you're rezoning, that means that you're in a universe of permissible activity within rezoning. You cannot go find a completely separate action from rezoning that is not related to rezoning, is not authorized by rezoning, and then say, well, that's part of the purpose of rezoning. It's not, and the title doesn't fit. On the standing argument, Maida's argument is effectively, well, you're going to lose, so you don't have standing. That's not standing. Whether the court ultimately defines whether we have a clear legal right or not does not change whether a ballot committee which under Michigan law represents the interests of circulators, signers, and members, has standing to challenge the denial of a ballot referendum. The certificate of insufficiency denied the referendum. Therefore, the ballot committee has standing to challenge that denial. That includes straight up seeking mandamus, period. But that also includes arguing that the denial was improper as a misapplication of law. If we accept made in the city's provision, the city could put in a 1 cent appropriation. Let's say we're in a charter that says only ordinance, and they put in a 1 cent resolution by resolution. Now we can't even challenge that and say you improperly denied our resolution. If that's a referendum, if that's true, the referendum power is dead. Any city could insert in an improper appropriation, and apparently a ballot committee can't even challenge that when that is the basis used to deny the referendum. That's simply not true. And if it is true, then there is no remedy for a denial of a referendum. That cannot be the case. So then we turn to the fact, and additionally, of course, the ballot committee has standing to challenge the denial of signatures. But then we turn to the appropriation itself. The city clerk said, I'm rejecting this because there's appropriations. But if those appropriations are legal, we have to be able to say that's not a valid basis, right? And the court says, and the ordinance says we'll sever it if it's illegal. And so we can say to this court, hey, the clerk was wrong. Those ordinances are illegal. So this ordinance needs to be severed. It's only on the tier 3 where you get into the situation of can you challenge the notice in the Act 425. Here, that construction is based on the circuit court's analysis that you can challenge the legality of a referendum petition before it's certified at the certification stage. If that is true, then a ballot committee also has standing to seek the validity of its ballot referendum. So we cannot, under the circuit court's ruling, the citizenry cannot uphold an illegal referendum. It can't vote for it. So if the ordinance itself is illegal, the citizenry cannot vote to uphold it. That is how we have standing under the circuit court's reasoning only. If this court adopts that this clerk has ministerial power and does not get to the legal power, then we don't have standing. It's only if you adopt this construction that the legality can be challenged ahead of time, does the ballot committee, as representing the interests of the signers, circulators, and petitions for the validity of a referendum, have standing to assert that the ordinance itself would be legal or illegal. One final thing, Maida frequently talks about zoning standing. This is not a zoning case. We have cited numerous cases in our brief where you can bring a referendum on a zoning ordinance. You do not need zoning ordinance. This is election law standing, and the court has been very, very clear that election law standing is some of the broadest standing you can have under the Michigan Constitution in the judicial system. Ultimately, this issue before the court, as made very clear by their argument that you can just put an appropriation in with never being challenged, is whether the right to referendum actually exists. Let's be clear, you don't have to be Sherlock Holmes to see what happened here. The rezoning was voted down by the Joint Planning Commission, so the city inserted an appropriation into an ordinance without noticing it. It's nowhere in that notice. That's not substantial compliance. Without noticing it, without the power to do so, and then turns around and says, well, you can't even refer that. That should alarm this court. That is a wiping away of the referendum power.
But counsel, correct me if I'm wrong, they had both trains running at the same time, right? They had the proceeding going forward with JPC, but they also had the ordinance in the works at the same time. Do I have
Correct.
that sequence wrong?
It had been submitted to the JPC, and the JPC was reviewing it without appropriations, I'll add.
Right.
And then the council published an ordinance that did not exist, introduced it, that published had no notice of the appropriations whatsoever. The Joint Planning Commission rejects the rezoning, and then the city council on May 1st votes for this ordinance that now has appropriations in it.
Got it.
I see my time has expired. May I briefly conclude?
Yes.
Thank you, Your Honor. Ultimately, the referendum is a powerful tool designed to empower the people to govern themselves. As the Supreme Court has said in Pharisee v. Secretary of State, the courts have a long history of actively protecting and enhancing the initiative and referendum power. This court should stand proudly in that long line of history and reverse the erroneous ruling below. Order mandamus that the signatures must be counted, that a certificate of sufficiency must be issued. We can come back here to challenge the legality after the referendum is passed, but ultimately, this court should just allow the people to have a vote as they are entitled to have and should have had over a year ago. Thank you.
Okay, who's representing the cross appellants? Please. I know we granted 15 minutes, but this doesn't strike me as an overly complex issue of intervention, but you give somebody 15 minutes, they use it, and give them an hour, they'll use it. So let's
Well, not me, Your Honor.
What's that?
Not me, Your Honor.
Okay.
Okay. May it please the court. Good afternoon. Scott Eldridge from Miller Canfield on behalf of the Michigan Economic Development Corporation. I'll be presenting only on this particular issue on behalf of the joint submission by the MEDC and the MSF. I will note for the record that the MSF's counsel, Eric Jameson from the Office of the Attorney General, is at counsel's table with me. I'd like to reserve 3 minutes for rebuttal if it's necessary. Trial court abused its discretion in denying the MEDC's and the MSF's joint motion to intervene in this matter for a simple reason that it deviated from the applicable standards and court rules and the case law, which we cite in our brief, which I will not repeat, and held MEDC and the MSF to entirely different standards not supported by those rules. Namely, A, the trial court seemed to place too large an emphasis on who actually owns the land at that moment in time. Here, that was MEDA. MEDA, the local economic development organization, temporarily holds title to that land with reversionary rights back to the MSF and the MEDC in the event of a breach of any of the agreements that MEDA enters into with the MEDC and the MSF for purposes of facilitating these projects. The court rules, of course, do not require actual land ownership. The court rules instead, under the intervention as of right rule, say an intervener simply has to have an interest in the property or transaction.
Why aren't your interests perfectly aligned?
Our interests are not perfectly aligned with, I presume you mean MEDA's and the city of Marshall. And it's a good question, Your Honor. And that's the second reason the court deviated from the applicable standards. The MEDC and the MSF is the proverbial straw that stirs the drink for these projects. This sort of mega site economic development project cannot happen without the MEDC or the MSF's involvement. Impossible, hard stop. That is because the MEDC and the MSF are statutorily and legally obligated to marshal these, no pun intended, marshal these projects from start to completion and beyond. The MEDC administers the programs that are at issue. The MSF controls the funds and approves the transfer of the funds, hundreds of millions of taxpayer dollars we're talking about, appropriated by the legislature and approved by Governor Whitmer to develop these very economic projects. They are charged with handling the entire project start to finish. Money cannot be spent without the MEDC or the MSF approving it. Properties cannot be transferred without the MEDC or the MSF approving it. No one else has that grand of responsibility over this project in this case. MEDA, and we don't dispute that the trial court properly granted MEDA intervention rights in this case, but it did so at the exclusion of the MEDC and the MSF. And MEDA, while they play an important role, plays a very small role in the overall development of this project compared to the MEDC and the MSF, again, which is statutorily and legally obligated to oversee this project from start to finish. The city, for its part, also plays a relatively small role in comparison to the MEDC and the MSF. It plays the role of, as we're here discussing so far today, the promulgation of the ordinance and assessing whether then it's subject to referendum. That's one small part. The MEDC is an indispensable party. The MSF is an indispensable party. But even so, even if their final end goal is aligned with the city and with MEDA to a large degree, at some point, the city has no more involvement in the matter and in the project. And MEDA no longer has a role in the project at the end of the day. Once MEDA then transfers the land to Ford eventually to take title of the property, but MEDC still has an obligation to monitor Ford's compliance with the CIP agreement and program that it is receiving funds under to the tune of over $200 million. And once the title is transferred to Ford or whoever ends up taking that property here, presumably it would be Ford, the MEDC and the MSF still maintain a reversionary right to the title if Ford doesn't fulfill its obligations under the agreements under which it's taking these funds. So that's maybe a longer version of the answer maybe than you were looking for, Your Honor, but it is they are an indispensable component to this project. And we think that holding the MEDC and MSF to a different standard because maybe we have the same overlapping legal arguments as the existing parties and Meta as an intervener. That is not the test. It's whether we have an interest in the property or transaction. And under the permissive intervention rules, of course, intervention is favored when we have common questions of fact or law with the actual parties. And so the trial court seemed to have held that against MEDC and MSF improperly by saying, well, you have the same sorts of legal arguments and they overlap or they're legally aligned. That's not the test either. And for those reasons, those two primary reasons, we think that the trial court abuses discretion. I'm happy to invite other questions. Otherwise, I'm inclined to rely on our briefing for the intervention components. We also briefed the merits on the substantive issues. I'm happy to entertain any questions you may have there. Otherwise, we'll rest on our briefs. Thank you, Your Honors.
Did you say 1 moment? Is that
Yeah,
what-
I just wanted to-
Yeah, absolutely. That's fine.
I will be mindful of this court's implied admonition not to necessarily take the full 15 minutes, which I also do not think will be necessary.
Well, I mean, it's
If it is, I'll
not
take
an
it.
overly complex. This particular issue is not an overly complex issue. The broader issue is more complex,
We certainly agree, Your Honor.
which has already been covered.
Right, and I will not be covering any of the substantive merits. So again, Your Honor, Robbie Doobie, Pro Hoc for cross appellee in this instance, Committee for Marshall, not the mega site. As a preliminary matter, we do renew our motion to strike the substantive briefing that they made. We had made that motion, it was denied without prejudice, and we think that a proposed intervener should not be briefing the substantive merits before being allowed to intervene. We further renew our motion to find it vexatious that they even did so, and do not request a ruling at this time, but do renew it before this panel. As a quick procedural note, the MEDC and MSF asserted that whether they are legally barred from participating in this litigation at all as a public body was not raised below. We are not appellant. We are cross appellee. We do not have to preserve that argument. This court can affirm the circuit court on any appropriate legal ground, and that is certainly an appropriate one. And that's the ultimate, as we see it, the ultimate issue here. As we get into this discussion of right to intervene and permissive intervene, Your Honor, I think made the excellent question of how is your interest different? It's not. Meta, they've said several times, Meta is simply an intermediary to hold the land until MEDC and MSF decide what to do with it. Meta has to get approval from MEDC and MSF to make final decisions. Meta is not the ultimate owner. What they're effectively saying is, well, Meta is just our agent until we decide what to do. But Meta is their agent until they decide what to do. Meta is representing the exact interest of MEDC and MSF here. MEDC and MSF want the project to go through. That is not the same as was the referendum appropriately referred or not, right? And so they keep saying, well, we want this, we want this project, and we're the ultimate owners of the project. That's not what this case is about. Ultimately, that's not even what the successful referendum vote will be about. This case is a matter of, was the referendum properly given a certificate of insufficiency or not? And I'm not getting into the merits there, just explaining that the issues are acceptably the same. They claim that, oh, well, the referendum is just one small part of the entire case. No, that is this case. And in this case, they do not have a right to interpret what the charter means, to enforce the charter, to enforce or challenge, even if this was a rezoning case, rezoning on property that they do not own. They have no rights to be here. And as evidence from the briefing, they're making the exact same legal arguments verbatim sometimes that Meta in the city has. So there's no risk of them not being adequately represented because all three parties do not want this referendum to be certified, do not want the ordinance to be overturned in any way, shape, or form. That's the same common interest and right. So to us, the most important and most alarming issue here is the fact that MEDC and MSF are a public body expending funds to defeat the qualification of a ballot committee. They are currently using state taxpayer dollars to intervene into.
How does this address the intervention issue though?
Because they cannot intervene if they do not have a legal right to be in the case at all. If they cannot expend funds to defeat the qualification of a ballot committee, they cannot intervene in this case. Now, one of the arguments they made is, well, it's for the Secretary of State to enforce. We're not asking the court to enforce and assess penalties on them. We're simply saying they claim they have a right to intervene. The law is very clear as a public body, they have absolutely no right to intervene. Because to intervene, they would be using public funds they would be using state tax dollar monies as a public body to expend for the defeat of a ballot qualification. That's what this case is.
I think it's a creative argument, but it's not your best one.
All right, and I will move on then, taking the hint from the court.
The short version is that the standard is on your side, that it's an abuse of discretion standard. And even if we three disagree with the outcomes the trial court reached, it's not so far beyond the pale as to warrant reversal. Do I have that about right?
You do have that right, Your Honor, and I would effectively make that my closing and adopt your words.
Very good.
Thank
All right,
you.
well, this was exceptionally well briefed, exceptionally well argued. I expect you'll have an opinion from us within the next few weeks. Yes.
Just as a quick reminder, appellants did file a motion to expedite, which was granted, indicating a June 19th date as the date. If the court does rule for appellants, that would be necessary to get onto the ballot. I just wanted to state that quickly.
Oh, thank you. I appreciate that. Thank you. All right, matter is submitted. We'll take a break to give everyone an opportunity who wants to leave, and then we'll call the next case.
rise.
Right. Calling the next case. Lebadoche versus Department of Treasury. That's item number 8 on our docket 365410.
Good afternoon, Your Honors. May it please the court, Adam Roos, Assistant Attorney General, appearing on behalf of the Michigan Department of Treasury, who is the appellee in this matter. Appellant was not endorsed for oral arguments on this case. This is a principal residence exemption case, Your Honors. And in this case, it is not the function of this court to second guess the tax tribunal's findings, so long as those findings are based on competent material and substantial evidence. There's ample case law holding that if the tribunal's findings of fact and conclusions of law are based on credibility determinations, such findings should not be disturbed on appeal, which is essentially what we have in this case. The sole issue for the tribunal was to determine whether the petitioner or the appellant occupied the property at 405 Barnes Street as his principal residence and therefore qualified for a PRE on that property. The tribunal reviewed the evidence, made a determination that Treasury's evidence was more credible, and specifically found that appellant's evidence was not more persuasive than Treasury's. So in other words, petitioner failed to meet his burden at the tribunal. It is not the function of a reviewing court to assess the credibility or resolve conflicts in the evidence. This is true even where alternative findings could also have been supported by the evidence on the record or because the court might have reached a different result. The tribunal considered Treasury's evidence, included the appellant's driver's license, his vehicle registration, voter registration, and an income tax return, which all listed his residence at a property other than the property he was claiming the PRE on.
Counsel, quick question about that. Do you reference the voter registration and driver's registration? These weren't actual copies of the registration or documents from Secretary of State. This was a skip trace.
Correct, it was a Lexis report, Your Honor.
Nobody disputed the reliance on a LexisNexis report?
That's not, no, nobody at the tribunal disputed that, and
it's not really, okay, all right.
So the evidence relied on by the tribunal to uphold the denial of the PRE more than satisfies the standard of competent, material, and substantial. The tribunal, as the trier of fact, is best positioned to determine how much weight and credibility should be given to that evidence. And substantial deference should be given by this court to those determinations. Although his brief is wide-ranging and raises several arguments and issues, his main argument appears to boil down to the fact that he believes the tribunal should have afforded more credibility to his evidence and less to Treasury's. However, respectfully, this court's review is, as I've stated, limited. And the judgment of this court as it relates to weight and credibility of the evidence should not be substituted for that of the tribunals. The issue today is only whether the tribunal's decision was supported by competent, substantial, and material evidence. And because the tribunal did have substantial evidence in the form of the driver's licenses, the tax returns, the voter's registration, the decision of the tribunal should be affirmed. Unless the court has any other questions, I would rely on the brief.
No questions. Thank you.
Thank you.
Matter is submitted. Turning now to item number 9. In re petition of Emmett County Treasurer for foreclosure. That's item number 366142.
Good morning, Your Honor.
Morning.
My name is Geraldine Brown. I'm an Assistant Attorney General, and I represent the Department of Health and Human Services in this appeal, and I'd like to reserve time for rebuttal.
All right.
Thank you. This case demonstrates the necessity and the importance of the intersection between the general Property Tax Act and the Estates and Protected Individuals Code, which we know as EPIC. MCL 21178T in the general property tax was written as an amendatory act to give full effect to the Raffaelli decision's mandate that excess proceeds from a tax sale would be returned to the owner. And the circuit court was given the task of determining the distribution of, and 78T puts it this way, the applicable remaining proceeds for claimants and other people. EPIC, on the other hand, is the probate court, and which has exclusive legal and equitable jurisdiction on all matters that relate to the settlement of a decedent's will and estate, including distribution. So Buford Hire, who owned the property, was the only owner of the property. No one else has ever had any ownership of that property. She's the one who should receive. She's deceased. But 78T made no provision for the death of a former owner. It did tell us that the only way that a claim was transferable was by testate or intestate succession. And as far as we're concerned, the only way that that can be determined is with a probate administration of a decedent's estate. So the circuit court cannot resolve the issues before it without EPIC, because this court said the will would have to be probated before Litzner could prove any entitlement to anything at all. And the only possible—
Didn't this court say that in dicta? That wasn't part of our holding in the initial iteration of this case?
That what? That
the will would need to be probated.
it did say, it was one of the holdings of the case. It says that she had sufficient interest.
The holding was whether or not she was a claimant.
That's correct.
And this court held she was a claimant.
And all it was determined was that, yes, she had sufficient interest to be a claimant. That's true. Thank you.
And then how does the Attorney General read Section 11 of 78T, which says this is the exclusive mechanism for a claimant to claim and receive any applicable remaining proceeds under the law of the state?
Yes, there has to be a mechanism, and the only possible mechanism is that everyone will make their claim the way that 78T suggests.
Did DHHS make their claim in accordance with 78T?
No, so the department did not make a claim.
So do you have standing at all?
Yes, the department believes that the will must be probated, and in the probate of the will, as the legislature intended for any assets of a decedent to be distributed under a
I don't disagree that EPIC controls the distribution of assets with respect to an estate, but I also think that we both agree that 78T provides the guidelines by which someone can be a claimant for any remaining proceeds from a foreclosure sale. And you have just stated that DHHS did not go through the necessary procedure to identify as a claimant. So, and you've now missed the deadline. So why, so even if the court had to go through probate to determine how much you get from the proceeds versus how much Miss Lindsay gets from the proceeds, you didn't file as a claimant timely under the statute that controls and expressly states it's the exclusive mechanism for remainder monies in foreclosure.
And we understand that.
And do you, out of curiosity, does DHHS now file as a claimant under these circumstances going forward?
Will we file as a claimant? The department cannot file as a claimant. It has a federally mandated requirement that it must seek recovery from the estates of beneficiaries of Medicaid.
Right, but I'm asking, going forward for future cases, it's possible that you could use this argument that you're presenting to this court today about Epic as the legal hook to be a claimant under 78T.
The department believes that to be a claimant, the only way, what he can do, he can open an estate and ask the court to appoint a personal representative who will then make the claim for the estate. But we believe that anybody, because the only way to claim is as under testate or intestate succession, we believe that anyone who is claiming as a derivative claim as by intestate or intestate succession is essentially claiming for the estate. MCL.
And I agree, all that's true, but you still have to be a claimant under 78T within a specific time frame. And Epic can give you the legal hook to do that, but you didn't do that, isn't that right?
Epic gives us the legal, no, we don't believe that Epic does give us we believe that it would have to be either the department would somehow, it would have to get a personal representative appointed and ask the personal representative to make the claim on behalf of the state.
They get a personal representative appointed, but still didn't file as a claimant.
But that was too late. They made a gesture of, but we believe actually Buford, our listener was actually the personal representative of the estate of Buford Hire at the time that she made the claim for the money. She had opened an estate, and although she had attempted to close it by sworn statement, her appointment still ran for a year. So she was still under appointment at the time that she made the claim. We will.
For my purposes, the disconnect is this. I agree with you that there is federal authority giving you the authority, maybe the responsibility.
Yes.
To open the estate and seek reimbursement through probate. I agree. I don't think anybody would disagree with that. I think the disconnect that I'm having is that you're somehow reading that to mean you can't file a claim outside of probate in circuit court to become a claimant. That is, at least based on what you filed, how you're reading that. And I don't see that you lack authority to be a claimant outside of probate.
Because the law says it must seek recovery from the estate.
But why is that exclusive? Why is that the only authority you have? Why can't DHS be a complainant? You're reading that as the sole mechanism, the sole avenue to seek reimbursement.
It's the specific wording of the federal statute.
But it doesn't say only.
No, okay. So you believe that the department.
No, it's not I believe. My point is that is the disconnect I'm having, that you believe that this is the sole avenue to obtain Medicaid monies through a probate estate, and you're reading that as the exclusive mechanism.
We do read it that way.
Well, yes. I'm not sure that you're right.
Okay.
But that's how you're reading the statute. Is there any case law that you can support, or any interpretation other than DHHS's analysis of what they think they're allowed to do?
I think that we've never run into anything like this before, that it has always been that the department can seek recovery from the decedent's estate. And in fact, in the priority of claims provisions, they are specifically listed as one of the priority claims. And for that reason, we have always collected from the estates. When someone does not open an estate for the family, we seek to get the public administrator.
In the wake of that case, this is a unique situation, and it seems to me that you're playing by the old playbook.
We also don't believe, Your Honor, that in any way the 78T wrote off any portions of EPIC. That, in fact, the EPIC itself said that it's intended as the unified coverage of the subject matter, and that is the distribution of the estates of decedents in Michigan. And it says that no part of it shall be considered impliably repealed by subsequent legislation if that can reasonably be avoided. And we believe that the simple solution is what the legislature preferred, and that was, since there is concurrent jurisdiction between the circuit court and the probate court, that the circuit court simply transfer or remove any of those cases that have only the assets of a decedent in them to be decided by in a death administration by the probate court, and to be completely resolved there. That's in both the Revised Judicature Act and in MCL 700-1303. And we know that that is considered a preference for the probate court to handle the situation, was the preference of the legislature. But again, Georgia Litzner, we do not believe, has shown any ownership, that the only way she can inherit anything is for a full probate estate of the money that belongs with Donna Buford Heyer, because she is the one who owned the property, and the assets should be returned to her. And the only way they can be returned to her is through a probate estate. And we believe that anyone who claims through a derivative claim should be considered claiming for the estate. It's essentially an Occam's razor. It's a simple solution. And the legislature understood that. They always knew that EPIC was out there when they wrote 78T, and they must have known that there would be cases in which there would be decedents. And EPIC is a mainstay. It affects so many different areas of law. We expect it to. And so they wrote this section saying, when you have this problem, transfer it and get the decedent's estate done the way we expect all decedent's estates to be done in this state. Thank you.
Good afternoon, Your Honor. Julius Moss on behalf of appellee Georgia Litzner. To begin, I do not know truly the answer, Judge Young, whether or not they actually have standing to be here, but I do know that we have the Emmett County as the appellee, the only other party of this transaction with the appellee. Would like to reserve 1 minute so that he may make a statement on this case for timing wise. The statute is clear under subsection 9 of 78T of the General Property Tax Act that the judge in the circuit court here was to determine the relative priority and interest of the claimants. The only claimant is my client, Georgia Litzner. The hearing transcript is clear, and MDHH concurred at the hearing about the validity of her claim that she was the only claimant. Therefore, she's entitled to 100% of the remaining applicable proceeds under section 78T.
And had MDHHS said, we have some claims in probate court, we're a claimant too, timely, then the outcome might have been different.
That is correct. That is correct. I think either they could have brought a claim. My friends on the other side say that the only mechanism that they claim is to go through a probate. Well, even if that is true, that mechanism still provided them sufficient timing to get a PR nominated under section 3203 of EPIC, which and allowed that PR to make a claim. We did not, Donna Beaufort passed away in December of 2019. Our motion as a claimant was not filed until May 14 of 2021. And that gave them a year to figure out if that's the mechanism that is needed to be for them to appoint a PR and to file a claim just like we had. And so because they failed to do so, they're now asking that our claim be subject to the administration of a probate under EPIC. It is true that this court in its 2023 ruling on this had a very narrow and limited holding as to whether Ms. Litzner was a claimant. It held that she was. It did say that the property devolved subject to the probate of the will. That went to the burden of proof, which is required by the claimant to show the validity of her claim. This court decided not to rule on the validity of her claim, given that a hearing had yet to be held at the circuit court level regarding proofs as to that nature and the value and interest of her claim as well as a priority. The valid probated will was omitted. Her interest was declared valid. And again, she was the only claimant at the hearing to claim the remaining proceeds, and therefore she's entitled to 100% of the applicable remaining proceeds. I would also like to note that the MDHS relies upon section 1303 of EPIC to seek removal of this case as one of their requested relief in this matter. I don't believe that there is concurrent jurisdiction under that specific provision of EPIC. In addition, subsection 2 of that section of EPIC requires a party to make a motion, and that has not occurred specifically because MDHS is not a party to this action, and further, the PR has not filed any sort of motion or any sort of filing in this matter since we began. Again, I will reiterate that this is the subsection 9 of section 78T of the General Property Tax Act is clear in the direction that the court is to follow. The court followed that correctly, and therefore appellee Georgia Litzner is entitled to 100% of the remaining proceeds. Besides that, I'll rest my brief unless you have any other questions. Thank you.
Douglas Curlow, appearing on behalf of the Emmett County Treasurer. It's no surprise to this court, I'm sure, that there's a lot of litigation that has been spawned by these tax cases and by the implementation of MCL 211.78t. The concern of the treasurers, and in this case, the Emmett County Treasurer, but more broadly, my firm also represents about 36 other counties and their treasurers in various litigations in state and federal court. The concern is that the payment not be paid to the wrong person. The concern is that there be a judicial determination as to who the money is to go to. There are a lot of these cases that are out there, I'm sure the court is aware of, where the claim is made, well, the taxpayer should just be able to show up and demand the money and the treasurer hand it over. Well, that's really not the way they want to do it. They want to have a judicial approval so that somebody can't come after them and say you paid the wrong party. No, we had an order. Now, which court, whose court? I felt like I should have had maybe a card table with a little stool between the two sides, because we really didn't take a position as to which court should make the decision, but there needs to be one. I would add, just from my brief, I fleshed this out a little bit. This court has a chance at this point to eat away one of the edges of trying to sound out what the practical nature of these claims should be, can address what kind of level of proof maybe needs to be submitted. It seemed to me that in the circuit court, that both sides were a little weak on what proofs they submitted to support their claims. And at the urging of my particular treasurer in this case, she is concerned that there be no way in which the claimants can try to avoid legal obligations by using MCL 211.78t as a device to evade other obligations that they might have or that might sit on the properties.
I understand your concern, but if this is a unique case that may rise or fall on standing, and if that's the case, I don't know that this is necessarily going to be the case that provides the guidance
that's true. Little by little, we have to work our way through quite a can of worms that Raffaele opened up. But I would note for the record that Raffaele has been proven to be correct last summer's decision by the federal Supreme Court in Tyler versus Hennepin County made clear that if the Michigan Supreme Court hadn't said that people were entitled to the surplus proceeds, well, they'd had a Fifth Amendment claim that would have given them that anyway. So it was really a very prescient decision by our Supreme Court. But again, from the treasurer's point, we just want to be sure that a judge is telling us who we're supposed to pay, so we have that security. Thank you.
We'd ask the court to look to the textual clues in 78-2T. It specifically referred to the applicable remaining assets that anyone was entitled to. And it did say that the claim was only transferable by testate or intestate succession. We do believe that requires an administration. It also said that it should not unjustly enrich a claimant at the expense of the public, and this definitely does that because it eludes the Medicaid claim, which funds Medicaid in Michigan. So thank you very much.
Thank you very much. Matter is submitted. Turning now to item number 10, Silver Valley Development versus Estate of Philip Schaefer, 365649. Go ahead.
Good afternoon, Your Honors. My name is John Abashevsky. I'm appearing today on behalf of the appellant, Silver Valley Development LLC. Before I forget, I'd like to preserve potentially just a small time frame for a possible rebuttal.
Okay.
And I'd like to ask a quick question. I'm confident that the court is fully familiar with the factual background of this case. Out of respect for your time, I can jump right into the pertinent legal arguments if you'd like, or I can get
Appreciate
into,
that,
okay.
yes.
Yep. Now, the two legal issues that the appellant has raised, the first and more complex and primary claim is the application of the doctrine of res judicata to a district court's determination as to rights to premises during a summary proceeding. And if applicable, if that is subsequently precluded from being relitigated by a circuit court, or in this case, the Mackinac County Circuit Court. The second issue is the effect, if any, of the May of 2023 dismissal that was sent in unilaterally from the land contract vendor after it had entered into a consent judgment with the appellant. Now, I do want to apologize for the brief that I submitted. After going through it a few times about a week ago, I realized the constant reference to the novation agreement. You're probably are sick of those two words already, having it been referenced so many times in all three briefs. But the reference to the novation agreement, I think, is a little bit misleading, and I have more specificity. It's more of the conclusive effect of the novation agreement had it been fully litigated aggressively by both parties in the district court summary proceeding. And
you acknowledge that it was not fully litigated.
Your Honor, I guess I'm not acknowledging that. I'm kind of saying this, and I'll explain why. It's kind of a multi-step explanation, if I can answer that shortly. But if the I guess there were two results that the novation agreement could have been subject to. It's either binding or it's not binding. If it's binding, the only difference in this case is a complete absence of the redemption rights that were awarded to Silver Valley Development by way of a consent judgment. If it's considered not binding, we have the same result that we have today. Silver Valley Development and the Shaver Estate, in lieu of butting heads over this novation agreement, entered into a consent judgment, awarding Silver Valley a 90-day redemption period to come up with roughly $248,000.
Where's the 90-day redemption period?
That's in the consent judgment, Your Honor. That
is the redemption period. Is that the term that's used?
I guess I would say, if I'm looking at the judgment itself, maybe that's maybe I'm getting that overlapped with a foreclosure sale, a judicial sale. I guess it's a 90-day opportunity to come up with funds owed, retention of the premises for the time being for 90 days. And if Silver Valley comes up with the money owed and pays it, the possession of the premises goes beyond that 90 days. There would be a warranty deed and fulfillment of the land contract. So what this consent judgment effectuates is a right to the premises, both to Silver Valley, and contingent on lack of payment, possession would then turn to the Shaver Estate after 90 days. So possession remained with Silver Valley, and there's an opportunity for Silver Valley to come up with the money owed and actually purchase the property and receive in return of fulfillment of the land contract, a warranty deed. Now, some of the cases that I think are more pertinent to this case, I don't know if this was cited in any of the briefs that were submitted, but we have 1300 Lafayette East Cooperative Inc. v. Savoy. Just for purposes of citation, we have 284 Michet 522. This is a 2009 case. In that case, you had a summary proceedings, and there was a consent judgment mutually executed by a landlord and tenant. And that case establishes that even if a consent judgment is the origin of a right to possession of property, it's still barred by the doctrine of res judicata, and therefore subsequently precluded from being relitigated in circuit court. And the verbatim language, and this is on page 530 of that case. Thus, where, as in this case, no claim for damages is asserted in the district court, the district court judgment is conclusive only on the question of who has a right to possess the premises. And that's barred by the doctrine of res judicata. Second, we have Sewell v. Clean Cut Management Inc. And that's 463 Mich 569. And I'd like to note that this should be given further consideration over JamCorp. JamCorp has been a case that's been cited throughout. This is a 2001 case. JamCorp was decided in 1999, both established by the Michigan Supreme Court. But what Sewell did was further establish the application of MCL 600-5750, which allows for claims that were not actually litigated in district court to subsequently be heard in circuit court. Now, this further establishes that cases in which rights to the premises were established cannot be relitigated in circuit court specific to those rights to the premises. And I'll read you the language verbatim here too.
Hold on one second. Before you jump into the language, I just want to go back to what Judge Hood asked, because it seems like this is all, you know, the case that you just cited was Sewell, and the question there and here is, have the questions been properly litigated? And I thought you started by acknowledging that the novation agreement had never been litigated in all its aspects, and instead a consent agreement which was reached. So doesn't Sewell actually cut against you and stand for the fact that under those circumstances, res judicata does not apply?
No, Your Honor, and that's why my prior apology with that, I don't think I indicated that accurately in my brief, but the end all goal with the novation agreement is to attack the redemption rights that were established in the summary proceeding case. So by applying the novation agreement during a subsequent circuit court matter, all that it would do is attack the 90-day period through which Silver Valley Development had an opportunity to pay for the property. So I would argue it has been litigated. I guess that's a question up to the court. I'll stand by that, but that's kind of an alternative argument. I don't think it matters. I think the novation agreement is absolutely moot. The time to argue the terms, whether they were binding or not, when it comes to the novation agreement, if it was not litigated, was during the district case, because the result of that, we have a right to possession of the property, which is fully reflected by one document being the consent judgment.
So is your argument that the consent judgment and novation agreement so overlap that litigation with respect to the consent agreement is in effect litigation with respect to novation?
Yes, Your Honor, because yeah, the only remedy that would be obtained by litigating the novation agreement in circuit court would be aimed at the redemption period. That's the only component of this case that, if removed, and I apologize, I keep referring to it as a redemption period, the 90-day period, if that's removed, then Silver Valley's out. But there's no other remedy that they could possibly obtain through the novation agreement. There was no opportunity to file a motion for reconsideration or an appeal because it was a consent judgment. And that right to the property stands. And the right thing to do here would have been for the Shaver estate to hold on to the property for 90 days, allow the redemption period to run. But turning back to Sewell, just getting to that language, and this is pretty, again, Sewell was determined 2 years after JamCorp, and it clarified the ruling in JamCorp. What JamCorp seemed to broadly state was that all claims that are not litigated in the district court summary proceedings can be litigated subsequently in circuit court. But it says nothing in the statute or in JamCorp stands for the proposition that having litigated in the district court the issue who has the right to the premises, that question can be relitigated de novo in a subsequent suit. Such an approach would empty MCL 600-5701 of all significance. And as I stated earlier, in 1300 Lafayette East Cooperative Inc., a consent judgment when it comes to rights to property in summary proceedings is barred by res judicata. So that must mean that the primary element of res judicata being litigated or could have been litigated, which the latter is essentially removed from this, given special treatment by MCL 600-5750. But that established that a right to possession of property acquired by way of consent judgment is in fact barred by res judicata. And then, Your Honors, I'd like to cover the permitted litigation. When there were several cases, JamCorp, 1300 Lafayette, Sewell, and Johnston. There were several claims that were heard subsequently in circuit court, but I'd like to emphasize that all of those claims in the cases that were emphasized amongst the three briefs were all requests for money damages. We had unjust enrichment, breach of contract, personal injury. We had an attempt to subsequently obtain rent that was due, attributable to time that post-dated the summary proceeding. So all of that is not applicable, but the language that I've cited today primarily, just a property interest established through the summary proceedings cannot be touched later on in circuit court. It can be appealed, but it cannot be relitigated. And I guess the question to be determined is a right to possession. Does that include the land contract vendee's right to retain possession for 90 days and potentially longer than that if the funds are paid? Because it definitely includes, it also bars any future litigation against the land contract vendor who is entitled to possession after the time period has run. So it protects both parties and it expedites the process of possession and a right to possession and a right to the property. Now, the second issue is the dismissal. This was in some ways a little bit more of a difficult subject to research at least than the application of MCL 600-5750. There's just no case law on it. It is a common procedure after you reach a judgment and all claims are finalized to send in a dismissal. It doesn't stay with the court. The court doesn't need to babysit the parties after a judgment's been reached. And what we had here pursuant to the consent judgment, Silver Valley, again, it was very concrete with a very strict timeline. Silver Valley had 90 days to come up with the money. If it didn't, then possession by way of an order of eviction would go back to the Shaver estate. So I don't see the presence of a dismissal in this case being a problem. What I have a problem with is the accompanying claim by the Shaver estate that this unilateral dismissal sent in and executed somehow negated the redemption rights. So I guess I would leave what I just said with the court to process that. There really is not case law that I could find personally. I conducted a lot of research, and the effect of a dismissal on rights to satisfy the contract for 90 days, 6 months, whatever it may be based on equity, it just doesn't exist. So I would ask that the court take that in consideration and just consider the dismissal as just inevitable after you settle a case. So and then I think that other than the addition of the cases that I introduced today that I don't believe were summarized with clarity in my brief, I'll just rest on the remaining components of my brief unless anyone has any questions.
Okay, thank you very much.
Thank you. Your Honors, Jennifer O'Brighter on behalf of the estate of Philip Bissell Shaver, and I believe that part of my time is going to be reserved for Mr. Brown. Just want to touch briefly on what appellant has raised, and primarily want to direct the court to the existence of that superior title holder. That superior title holder was the one who ultimately negotiated the dismissal with the estate. That's why that dismissal was submitted.
This is the vendee.
The vendee of the land contract. The plaintiff appellant in this case had no legal interest in the property prior to the filing of the district court matter. They were included on that district court matter because administratively there hadn't been a record created to allow a marketable title to be passed from the estate. And so I want to really refocus the court's attention to the fact that appellant comes to the court, wants you to consider that they are the only party here. They did not make that vendee a party to the circuit court matter. They could have, because certainly that the vendee's actions impacted the ability to move forward with his case. He had an absolute right to appeal that dismissal. It's in the statute. He was served with the dismissal. The plaintiff, I guess the entity was served with the dismissal both by the court and by the Shaver estate, which started a time clock. 56 days later, the circuit court matter was initiated. And so if the court is going to consider res judicata in this matter, I think we need to look at that dismissal and the complaint that was filed.
It almost works the opposite way.
It does, Your Honor, and I would argue that it does work the opposite way. And so I'm asking the court to just go ahead and find, yes, res judicata applies, but not in the way that appellant argues, in the way that the estate and Mr. Brown on behalf of the purchasers would argue that that dismissal, it was a final order. The appellant had the opportunity to challenge that final order. He had the right to appeal it, chose not to appeal it, and then filed this motion instead. My client would argue it's frivolous, and we would ask the court to remand only for purposes of calculating whether any attorney's fees are due to the defendant appellees in this situation. Thank you. Are there any questions?
Good afternoon, Your Honors. Peter Brown on behalf of the appellee. We're the current owners of the property, Sean and Tamara Borowitz. I'll be brief. I'll likely rest largely on my briefs, and I don't want to restate some of the arguments of sister counsel. But I do want to address the res judicata issue first. I think the key issue that your honors have already pointed out is whether the novation agreement was litigated in the district court. As the court knows, Jam Corp is the leading case, but there are also other cases, Dart v. Dart and Sewell versus Clean Cut Management, and when read in conjunction with the relative or the statute MCL 600.5750. So long as an issue isn't actually raised and litigated and decided in the district court, that is not barred by res judicata in a subsequent proceeding. And so obviously if Silver Valley would have come into the district court proceeding and said, look, this novation agreement isn't enforceable, and that would have actually been held on the record, there would have been a trial and there would have been a determination as to the enforceability of the novation agreement at that time, we might be in a different situation, but we know, of course, that didn't happen. So pursuant to the case law and the statute that I cited, the case law obviously is that res judicata does not apply to the circuit court's decision in this case to hold that the novation agreement barred any interest or extinguished any interest that Silver Valley may have claimed in the property. So I don't think res judicata is applicable here to the extent it is. Obviously, it applies to the dismissal in a district court case that was not appealed by Silver Valley.
But hypothetically, had the district court gone through the hearing, had it not just been marked as an exhibit, never introduced, then depending on the outcome, it would take it outside of the statute under Sewell.
I would agree with that, Your Honor. But that, of course, would never happen. And if that would have happened, I mean, and it happened in the circuit court subsequently, when we actually talk about the novation agreement, there's no question that was it was an overly complicated document. I'd give you that. But all it was an assignment of the vendee's interest to the Jorgensen Trust. And so at the time when they showed up for this trial and the arguments that are being made by brother counsel that somehow the consent judgment it gave them, I think his quote was, gave a property interest in the property is just not true. So the consent judgment didn't revive a property interest. It didn't revive Silver Valley's interest in the land contract. And so therefore they had no property interest. They had no right to pay off the land contract because they weren't a land contract vendee anymore because they clearly had waived their rights. So, and of course, I guess the last issue I'll briefly touch on was, I think we already have, is the dismissal of that district court case. While there was a consent judgment that was entered, that provided that an order of possession would enter in 90 days if the payment wasn't made. So this consent judgment wasn't a settlement as proposed. It was a consent judgment that was entered with things to occur in the future. But then the two parties to the land contract, the Jorgensen Trust and the Shaver Estate, terminated the land contract, and then there was the dismissal that was entered. To the extent Silver Valley had any objection to the termination of the land contract and the dismissal that was entered, they would have had filed their appeal as a right at that particular time. When they didn't, any interest that they even claim, alternatively, any interest that they claim in the consent judgment is now barred. I'd be happy to answer any questions the court may have. Thank you, Your Honors. Any rebuttal?
Now, again, I think the novation agreement at this point, I should have specified this much earlier in this case, but it is moot. What's being relitigated are the rights to the property. And that is Silver Valley's right to the property for continued possession for 90 days with an opportunity to come up with the money, and subsequently the Shaver Estate's right to the property. That's what's being litigated, because the novation agreement is an instrument to try and negate that, but it's really not the novation agreement that has to be litigated. It's just the property rights. And again, as supported by 1300 Lafayette and Sewell, property rights determined, even if by way of consent judgment in the district court, are barred by res judicata. They're barred by res judicata. They're precluded from being litigated once again in circuit court. And then again, just on the dismissal, again, a case can be dismissed. Are all of the rights that are awarded to the parties in a consent judgment also dismissed with that? Are they terminated? If you have, for example, a consent judgment with installment payments for 3 or 4 years, you enter a dismissal, you dismiss the case with prejudice, but those payment obligations and benefits going to the the payee are not terminated with it. And that's what my position is with the dismissal. It doesn't just terminate all redemption rights that were granted to Silver Valley Development. And nor does it terminate, well, yeah, I'll just leave it at that. Thank you.
Thank you. All right, matter is submitted. Turning now to, I believe, item number 11, which is Cook versus Munson Medical Center, Inc., 365373. Do we have an appellant here? Nobody checked in? Okay. All right.
Good afternoon, Your Honor. Sandra Lake on behalf of the defendant appellee. I'm going to rely primarily on my brief. I just want to highlight basically the crux of my argument, which is this. The plaintiff complained of wrist pain in the course of medical treatment for some very serious injuries following a motorcycle accident. That wrist pain complaint was documented in the medical records and we've attached them. He was assessed for that complaint and he was reassessed really head to toe just due to the extensive nature of his injuries throughout his entire hospital stay. Further imaging was not done because those assessments by and large were normal. It's noted, if you see WWP in the records that I've cited, that means a warm and well perfused. That means he had good blood flow into his wrist. There was no swelling. And other than a few moments where he had reduced grip strength, otherwise grip strength was noted as strong throughout his stay. So the question really is, okay, he's been assessed. Was that assessment proper, thorough? Should something else have been done or not? And that's medical malpractice. That's my argument. Thank you.
Thank you very much. Any questions? Yeah.
Pardon? Thanks for sticking around.
The matter is submitted.
It's much easier than some of the others you've had this morning.
All right. Well, I believe that concludes the docket today. Thank you very much. Yep, you too.
Thank you. As long as you're presenting your assessment. Oh, absolutely. You could have left that. Thank you. Absolutely. Thank you. Thanks.